the Acting Chief Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Call the case.
Your Honors, this is a continuation of the oral argument in the consolidated cases docketed as GR number 208912, Amadea Angela Aquino, petitioner, versus Rodolfo C. Aquino and Abdulah C. Aquino, respondents, and GR number 209018, Rodolfo C. Aquino, petitioner, versus Amadea Angela K. Aquino, respondent.
The counsel for petitioners, there will be some justices who will still be asking questions. Can you please take the podium?
One appearances, Your Honors. For the petitioners, Attorney Charles Anastasio, lead counsel for Amadea Angelo Aquino in both cases. Attorney Susan Cariaga, collaborating counsel for Amadea Angelo Aquino in both cases. Attorney Leilani Yang Espejo, counsel for Rodolfo Aquino in both cases. For the respondents, Your Honors, Attorney Geraldine Kemosing Chiu, counsel for respondent Abdullah Aquino in GR 208912. For the Office of the Solicitor General, Solicitor General Jose Calida. Assistant Solicitor General Marisa de la Cruz Galandines. Assistant Solicitor General Bernard Hernandez. Assistant Solicitor General Rex Bernardo Pascual. Assistant Solicitor General Marisa Macaray Guillen. And Assistant Solicitor General Gilbert Medrano. Amicus Curiae, Your Honors, we have Dean Cynthia Del Castillo. You may now be seated.
Justice Javier.
Yes. May I ask Miss Maggie to please answer some questions? Can you please approach the podium?
Good afternoon po, Your Honor.
Yes. Good afternoon, Miss Maggie. Your name is not Aquino in your birth certificate. Yes.
That is, opo.
Yes. What is your name in your birth certificate?
So, dalawa po yung birth certificate ko. Meron po akong birth certificate na Amadea Angela Aquino.
When was this recorded?
Your Honor, hindi po siya na-register. So, ito pong birth certificate na to, ito po yung galing sa ospital. Galing po siya sa Davao Doc. So, dito po yung original ko po talaga. Pero hindi po siya ni-record, na-register po.
But it's still with the hospital?
It's correct. That's correct, Your Honor.
Yes, and your name there?
Is Amadea Angela K. Aquino.
Yes. Aside from that birth certificate, which is unregistered, what other document bears your name as Amadea Aquino?
Right now po, Your Honor, yung document meaning the one
Document? Say your baptismal certificate.
Opo, Your Honor, yun po. Yung mga originals ko po, yung baptismal certificate
Yes.
ko.
What name is born in that certificate, your baptismal certificate?
Amadea Angela Aquino po.
Amadea Angela Aquino.
Opo.
And one of your godfathers
Father.
there
Opo.
was Abdulah.
Yes.
Your uncle?
Opo, si Tito Nonoy po.
Yes.
Tito
Is his
Abdulah.
name also reflected in that baptismal certificate?
Opo.
Yes. Did you ever use the name Amadea Aquino in your official transactions? For example, in your school records?
Yung sa beginning po, yung mami ko po ang naggawa from the beginning. Pero nung nagkamalay po ako, ang pinagamit na po sa akin yung Angela ho po.
Were you ever required to submit to any office your baptismal certificate?
Any office?
Yes. Like, for example, did you go to a Catholic school?
I went to a Catholic school po.
Yes. Catholic schools, I understand, require baptismal certificates. Did your school require you to submit your medical certificate? Or your baptismal certificate, rather?
Hindi ko po alam nung maliit pa po ako kung ano po yung requirements,
All
Your
right.
Honor.
So, can you obtain that birth certificate that is on file with the hospital where you were born?
Your Honor, right now po, I went to Davao and I tried to get a negative for the birth certificate that says Amadea Angela Aquino. I just went there po last week. And then, ngayon po, when hiningin po yung Amadea Angela Aquino, lumabas po Angela Ho, which is a completely different birth certificate po. So,
Angela what? What is the surname?
Angela Ho po.
Ho?
Opo.
Who is Ho?
So, yung...
Who is Ho?
Yung...
The stepfather?
Yung pong na-meet nung mami ko nung mga 3 years old na po ako, siya po yung nag-pop out, which is nagulat po ako. Maski yung mga tao po sa statistics office, they don't understand what happened because in my original, even in the Philippine Statistics Office, it says there, Angela Aquino, born in Davao po. Tapos nung tinatry ko po kumuha ng negative, dahil hindi po rin-register yun, nag-pop out po yung Angela Ho, born in Caloocan City po.
Really?
So, Your Honor, maski po sila...
Do you have any connection to Caloocan?
Well, yung
Did you ever live there?
Nung nagkabago pong... may na-meet po yung mami ko nung... Kasi 17 years old lang po yung mami ko nung pinanganak ako. So, medyo nung... After 2 years, 3 years, may na-meet siya. They eventually moved to Caloocan. So, yun po yung ginawa po nila if you call it fabricated, I don't know what, fabricated birth certificate, yun po itong galing pong Angela Ho. Yun po ito.
Who fabricated it? Would you know?
Well, actually...
Who had the motive or intention to fabricate it?
Well, they
Even
did-
the hospital records?
Yun nga po nagugulat nga po din ako, hindi ko po alam kung anong nangyari doon. Kasi before, when I tried to get it, everything was fine. But it was not it was Amadea Angela Aquino. So now po,
Did
when
you
I asked-
have that? Do you have a copy of that where Amadea Angela Aquino is the indicated name.
Yeah, actually, I did bring it.
You have it?
Yes.
Do you have also the birth certificate on file with the hospital when you were born?
It would be with my lawyer who helped me in the regional trial court. We would have that.
Can
and it
you
would be
please
at the
submit it also to the court? And then my last question, thank you very much for that, Miss Maggie. My last question to you is this. How long did your father and mother live together? Did they ever live together? If
my-
at all they lived together
Well, my
before
dad-
you were born?
My dad turing po, I know they were together for a year.
Just a
And-
year.
Just a year, correct po. So, ang nangyari po, my dad was 29, I think, that time, and my mom was 17.
They
My da-
never lived together?
They lived po together.
They lived together for 1 year.
Opo.
Yeah, yes, but before they lived together, did they already have a relationship?
Well, opo.
For how many years before that?
Siguro maybe a few more months before that.
Okay, a few more months before that.
Yeah.
Which means 11 months?
No, before after the 12, let's say 1 year, and then before they met like 3 months.
So 2
before
years.
that. About like that.
2 years? They,
Aba-
they had a relationship for 2 years. 1 year, they lived together.
I'm not specifically sure how long, but it was about, let's say, the whole courting thing and the time that they wanted to be together. I would say about 2 years. So
Okay,
maybe a
and
little
all
less.
those 2 years, you were conceived only, presumably,
So
presumably
Before
during
my
the
dad
last
died.
month that before he expired or died.
died po.
Alright.
Opo.
Thank you very much,
Thank you po.
Miss Maggie.
Yes, Justice Alameda.
Counsel,
Yes,
how long has your client been aware of the existence of the certificate of live birth of Maggie with his father, Enrique Ho?
Maybe my collaborating counsel can answer that, Your Honor, please.
Respectfully entering my appearance, Your Honor, for
Please.
Amadea Angela Aquino.
Same question, counsel.
How long has my client known of the
Been
existence?
aware, yes.
She has been aware of it since she was a young girl, Your Honor.
So, the certificate of live birth was never presented before the trial court. Am I right?
Yes, it was not, Your Honor.
Do you know the presumption on procedural law about suppression of evidence?
Yes, Your Honor, but
Can you tell the Honorable Court of the presumption?
the presumption is it is adverse to you if not presented, Your Honor.
Okay. So, basing it on the certificate of live birth of Maggie, what was her legal status upon the issuance of the certificate of live birth?
Her status, Your Honor, was she was the acknowledged natural child of Arturo Aquino.
No, the certificate of live birth with his father as Enrique Ho. I mean,
Yes, Your Honor. She would be illegitimate, Your Honor.
a natural child of Enrique Ho and Susan Kwan. Am I right?
Yes, Your Honor.
Okay.
That would be the presumption.
And what was the legal effect of the subsequent marriage of Enrique Ho and Susan Kwan to the status of Maggie as a natural child?
She would remain illegitimate, Your Honor, because she was never acknowledged as the natural child.
She becomes legitimated.
Yes, she was never legitimated by Enrique Ho and Susan Kwan, Your Honor.
Why is that so?
There was never an overt act on the part of Enrique Ho to change her status to legitimated.
Am I correct to say that there is a signature on the certificate of live birth of Enrique Ho?
Yes, Your Honor.
Is
there
it not, it does not amount to recognition insofar as you are concerned, counsel?
No, legally, Your Honor, no, considering that Enrique Ho was aware that it was merely a simulated birth certificate, void from the very beginning, Your Honor.
What is the presumption on the part of the certificate of live birth issued by the civil register?
The presumption,
Is there a presumption of validity on it?
yes, Your Honor, but if I may humbly say, Your Honor, in the case of Babiera versus Katotal, according to the Supreme Court, this presumption is destroyed by the facts that surely the birth certificate was simulated.
So the presumption stands until it's destroyed.
Yes, Your Honor. If there are facts militating against its validity,
Okay? Did you question at any time this certificate of live birth of Maggie up to this date?
the first time that it was presented in evidence, Your Honor, officially, was before this honorable court, and there was an opposition to it made in the reply of Amadea,
But
Your
you
Honor.
said that you were aware of the existence of the certificate of live birth even before.
Yes, Your Honor, but the fact is, the respondents, Abdulah, Rodolfo, and all the other Aquinos, knew also of that, including Miguel Aquino himself. So it was like an open secret to everyone in the Aquino clan that although Maggie has this birth certificate, the truth is she is really the acknowledged natural child of Arturo.
So we agree that you never questioned the certificate of live birth.
We question it.
Officially.
We question
in a legal
it.
proceeding.
Before this honorable court, Your Honor, it was questioned.
There was no action taken to question or nullify or to correct at least the certificate of live birth.
Yes, prior
There was
to
no action.
no action prior to the action here, Your Honor.
Okay. So, in this motion to be included in the distribution and partition of the estate of Miguel Aquino, your client now wants to be declared as an heir of Miguel Aquino by right of representation. Am I right?
Yes, Your Honor.
So, she wants also to be declared a natural child of Arturo.
Yes, Your Honor.
Okay. At the same time, there is a presumption that she is a legitimate child of Enrique Ho because of the certificate of live birth.
That is correct, Your Honor.
So it seems that there is a dual personality here of Maggie.
That is correct, Your Honor.
Now, referring to the motion to include in the distribution and partition of the estate of Miguel Aquino filed before the trial court, do you equate this as an action for compulsory recognition of filiation
Yes, Your Honor.
by mere motion?
Yes, Your Honor.
What is your basis, counsel?
Considering that the main action was for the settlement of the estate of Miguel Aquino, Your Honor.
So is this allowed under the rules?
We believe so, Your Honor.
Is raising the issue of filiation collaterally in an estate proceedings is not allowed under the rules, counsel, pursuant to Igunco versus the Court of Appeals. So, can you touch this? You're saying otherwise, can you touch this in your memorandum?
Yes, Your Honor.
Okay. Now, was a hearing conducted before the trial court where you presented both testimonial and documentary evidence to support the filiation of Maggie?
There was a hearing, Your Honor,
Hearing on what, counsel?
on the motion to be included in the distribution of the estate of Miguel Aquino.
So, there was actually no hearing but a hearing only on the motion.
Yes, to hear the motion, but there was no, the court and the parties did not see any need to present evidence or try it, considering that at the time, the respondents here, Abdulah, Rodolfo, and the other members of the Aquino clan, did not question any of the claims of Amadea Angela Aquino.
So you just presented your evidence attaching it to the motion.
It was contained in the motion, Your Honor.
And there was no actual hearing at all.
There was a hearing, Your Honor.
Hearing on, just the hearing on the motion, I want to be clarified on
Correct,
this.
Your Honor.
There is no presentation of evidence.
There was no
which transpired.
There was no presentation of evidence in the sense of documents or testimonial evidence were presented, Your Honor, considering that the allegations of Amadea Angela Aquino were never disputed by respondents Abdulah and Rodolfo, Your Honor. So there was an implied admission judicially.
Now, in this petition, you also ask that Article 922 of the Civil Code be declared unconstitutional.
Yes, Your Honor.
Yes. And for being discriminatory and violative of the Equal Protection Clause.
Yes, Your Honor.
Again, can you tell us what is the basis of this provision, the Iron Curtain Rule?
The basis is Article 992 of the Civil Code, Your
And
Honor.
what is the basis of that absolute bar on the part of the illegitimate children to succeed ab intestato against the properties of the legitimate children, legitimate family?
The presumed animosity and antagonism between the legitimates and the illegitimates, Your Honor.
I go to the presumption of animosity.
Yes,
Is
Your Honor.
this presumption conclusive or disputable?
It's disputable, Your Honor.
It's disputable.
Yes.
So, meaning to say that the claimant can present evidence to show that there is indeed no animosity between the legitimate and illegitimate family.
Yes, Your Honor.
So, meaning to say that a person like Maggie can present evidence to dispute the fact that she cannot inherit from the legitimate family. Am I right?
Yes, Your Honor.
So, in saying so, do we need to declare as void or unconstitutional this particular provision of Article 992?
There is no need to declare it unconstitutional in the entire sense that the Article 992 is unconstitutional. What we prayed for in the reply, Your Honor, is as to the interpretation of the term relatives.
So, now you're changing your prayer that there is no need before this court to declare it as unconstitutional.
In our reply, Your Honor, what we said was there is an unconstitutional interpretation of Article 992 if we say that the term relatives in Article 992 also refers to grandparents. In that sense, if we follow that kind of interpretation, which is the interpretation of this Honorable Court in Diaz versus Intermediate Appellate Court, that would be unconstitutional.
So your position now is that there is absolutely no bar to an illegitimate child claiming ab intestato to the legitimate family.
There is a bar in Article 992, Your Honor.
But this is merely a disputable presumption.
But
it is not absolute.
it does not extend to grandparents and grandchildren inheriting from grandparents.
I'm asking you about the presumption of animosity. Is this conclusive or disputable?
Disputable, Your Honor.
Okay, that's all.
Justice Leonen.
Can you remain, counsel? I just have a few questions. In the hearing on the motion for inclusion, you said that there was only a hearing but no presentation of evidence. Is that not correct?
Yes, Your Honor.
And your position here is that is because there had been an admission on the part of Mr. Abdulah Aquino contained in his comment of November 14, 2003, specifically paragraphs 2 and 3 of that comment of November 14, 2003. Is that not correct?
Yes, Your Honor.
And reading the admissions on paragraph 3, Abdulah Aquino admitted the handwritten instructions and also that he bequeathed the lot in front of Linda T. Aquino's LTA residence along Bolian Street shall belong to Amadea Angela Maggie Co. Aquino.
Yes, Your Honor.
Yes, and because it was a comment, a pleading that was filed by Abdulah Aquino that amounted to a judicial admission. Is that not correct?
Yes, Your Honor.
And there are two ways of establishing evidence, correct?
Yes.
One is by admission, and
Yes.
the other one is by presentation of evidence, correct?
Yes, Your Honor.
If there is an admission by the adverse party, that means that there is no need for presentation of evidence, correct?
Yes, Your
A
Honor.
judicial admission, on the other hand, has the equivalent of a rank of, let us say, a judicial notice to be taken by the court because it is already established upon admission by the parties. Is that not correct?
Yes, Your Honor.
You will cover this in your memoranda, and I hope that the counsel for the respondents will also cover whether or not paragraph 2 and 3 of the comment, not with the court, but the comment on the motion for inclusion dated November 14, 2003, is already considered as an admission. That will be covered in your memoranda. And also, your claim is that the birth certificate was only presented with this court. Is that not correct?
Yes, Your Honor.
And the birth certificate, according to you, was simulated. Is that not correct?
Yes, Your Honor.
It was not the doing of the respondent. Is that not correct? The petitioner. Is that not correct?
Yes, Your
By
Honor.
petitioner here, I mean Maggie. I do not mean Rodolfo because there is another petition with him as the petitioner. So the petitioner that I'm mentioning is Maggie. It was simulated, according to her, because of the stigma of an illegitimate child, and the mother, following motherly instincts, wanted to protect her because at that time in Davao City, she felt that there would be certain difficulties of Maggie as she went through her schooling if she was considered as an illegitimate child. Is that not correct?
Yes, Your Honor.
Therefore, you had a reason not to present yourselves the birth certificate because for the petitioner, it was considered as only simulated, correct?
Yes, Your Honor.
And therefore, the presumptions that arise out of a birth certificate should be taken with that as a consideration. Is that not correct?
Yes, Your Honor.
But, all of these are factual issues. And because all of these are factual issues, would you think that this should be considered and remanded back to the trial court in order that it be properly heard?
We will submit to the discretion of the Honorable
Okay.
Court.
Are you confident, this is just me, not the court, okay? Are you confident of the filiation of your petitioner such that your petitioner will be willing to submit, if ever, if ordered by the court, this is just an idea, to DNA testing?
We are 1,000% sure about that, Your Honor.
1,000, that is
Yes,
10 times 100%,
Yes, Your
counsel. And I don't think there is 1,000%.
Okay.
Correct? So maybe just, you can
100.
just say 99.99%, just because DNA testing is 99.99%.
Correct, Your Honor.
Would you know of any case decided by the Supreme Court where the Supreme Court itself ordered DNA testing?
The case of Senator Po, Your Honor.
We actually did not order it. She did it willingly. But there was a first case. You remember that case?
I cannot.
Well, it was penned by the acting Chief Justice, Antonio Carpio, but perhaps you can research on it. But this is not yet an order from the court because any order from the court relating to DNA or compromise will always be done collegially, and we have to tackle whether this should be tackled by this court or by some other court. Okay. There was a collateral attack, assuming that it was a collateral attack. But the case that you have now is unique because, in truth and in fact, 10 months is really the the gestation period of a human baby. Is that not correct?
Yes, Your Honor.
Yes. And Maggie was born 9 months or close to 9 months
200.
after the death of the alleged father, who was then 29 years old. Correct?
Yes, Your Honor.
On the other hand, therefore, it was not possible to avail of many of the remedies that are now contained in Rule 172 because the father had already died. And this case is unique because during the lifetime of the parent, it would not have been possible because of the improbability of being able to do that unless you have invented the time machine. Is that not correct?
That's
but
true.
you couldn't because none of us have invented the time machine, correct?
Correct, Your
Okay. And also that when Maggie reached the age of 18, there was still no jurisprudence which said that they had to prove filiation 4 years after 18. In fact, it came after her 18th birthday that there was very clear definitive ruling by the court. Is this not correct?
Yes, Your Honor.
Of course, you will cover this in your memoranda. Is that not correct?
Yes, Your
And
Honor.
I hope that the Respondents' Council will also cover this in your memoranda. I am just trying to clarify the position that you are presently taking here. Now, in terms of interpreting 992, there are 3 layers now. The first layer is that you are claiming this is the absolutist position that in your reply you did say, in your memoranda you did say, assuming for the sake of argument that Diaz is valid, it is now unconstitutional because of the equal protection clause and social justice in the Constitution. Is this not correct?
Correct.
That's the absolutist position. There is the medium position, and the medium position is that the interpretation of Diaz should now be taken into consideration or reviewed by the court because of the Constitution, which was not raised in the case of Diaz. The amicus were all civilists. None of them raised the constitutionality of the interpretation. And now your claim is, considering the Constitution and considering the newly ratified UN Convention on the Rights of the Child, particularly Section 2, this court should revisit its interpretation of that. That's the second interpretation, correct?
Yes, Your Honor.
And the third interpretation is that the bar, and this was just suggested by Justice Alameda, quite brilliantly, in fact, that the bar is merely a disputable presumption because the bar is based on animosity between the children, and were it not for the fact that there is no animosity, then there could be representation to the legitim of the father who will compulsorily inherit from the grandfather. Is this not correct?
Yes.
So there are 3 options.
Yes.
But overlaying all of this is the question of how the court will look at illegitimate children, correct?
Yes, Your Honor.
Now, if the court remands the case in order to prove filiation, if ever it is necessary to prove filiation, then therefore the court has to rule on how to interpret 992. Is that not correct? Because of judicial economy.
Yes, Your Honor.
Because if we remand it and later on say that there is an absolute bar still, then all the proceedings in the lower court will not be given a chance. Is that not correct?
Correct.
So it will just be a waste of time.
Yes.
Waste of time, waste on effort. The time of very brilliant counsels will be affected. So before we remand, therefore, the court has at least to interpret again 992 and say whether or not Diaz still holds or any one of the 3 options can be taken by the court. Is that not correct?
Correct, Your Honor.
Yes. However, also that we have to take into consideration the new submission of the amicus, particularly Professor Pangalangan, which was highlighted quite emphatically during the interpellations the week before by Justice Mon Hernando, of the actual number of illegitimate children now living in our country. Is that not correct?
Yes, Your Honor.
And I hope that both the counsel for the petitioner and the respondents will take into consideration this new context that was provided to us, which was not available in the case of Diaz. Would you remember in the case of Diaz,
Yes,
whether any of the amicus presented statistics from the NSO?
I don't have the material on that. I don't know, Your Honor.
Okay. So, well, with respect to your case, there are several things which we want you to attend to in your memoranda, which includes whether there has been a factual determination of the filiation, what are the unique circumstances in the case, why was there a collateral, quote-unquote, attack, also the 3 levels of interpretation in relation to the Constitution. By the way, counsel, just out of curiosity, is your client, does your client already have a descendant?
Yes, yes, Your Honor.
And is she married?
Not married, Your Honor.
Not married. So whatever we rule in this case will also affect the descendant of Maggie, correct?
Yes, Your Honor.
And of all the illegitimate children, 53% of this country, 53% of all children registered with the NSO, if I recall correctly, all of them can have descendants too, correct?
Yes, Your Honor.
And is marriage a compulsory requirement for every couple? In other words, are you compelled to get married?
You are not, Your Honor.
No, there is no compulsion to get married. Getting married is a status which you choose. Is that not correct? And
Yes.
apparently there are many that now choose not to have the disturbance of a spouse. Is that not correct?
That's
I'm of
true.
course stating my bias. That is a very leading question. Is that not correct?
Correct, Your Honor.
Well, not disturbance. The pleasure of having a legitimate spouse is as much a pleasure when you do not have a legitimate spouse. But I'm just interjecting some humor here. In any case, therefore, kindly also cover the current context. I have no further questions.
Are there further questions for the justices, for the counsel for petitioner? There being none, thank you. You're excused.
Thank you, Your Honor.
We will proceed with the presentation of or interpellation of counsel for private respondents. Kindly take the podium. Okay, you have 10 minutes for your presentation. Thank you.
Good afternoon, Your Honors. The issues in this case are not novel. They had already been raised and ruled upon in a long line of cases, and the rulings of the Honorable Supreme Court in those cases have always been consistent. There is no necessity to depart from these long-established doctrines. The rights of an illegitimate child arise not because she was the true or real child of her parents, but because under the law, she had been recognized or acknowledged as such a child. The alleged overt acts of the Aquino clan did not constitute an acknowledgement of petitioner's illegitimate status, but a mere grounds by which she could have compelled acknowledgement through the courts. Unfortunately, petitioner's right of action to compel acknowledgement is already barred. Under Article 285 of the new Civil Code, petitioner had up to 4 years from attaining majority age within which to file an action for recognition. For all intents and purposes, petitioner was a minor at the time of death of Arturo, even if she was born before the death of Arturo. Petitioner's claim of filiation cannot be appropriately made through a mere motion. A claim for acknowledgement requires judicial action. Jurisdiction over the same is lodged before the family courts. On the other hand, the jurisdiction of the intestate court is limited. A person can maintain a complex action to compel recognition at the same time to obtain relief in the character of an heir, provided always that the conditions justifying the joinder of the two distinct causes of actions are present in the particular case. An action to compel recognition, which is a civil action, cannot be joined with a special proceeding. Even if we invoke the family code, petitioner is still barred. There are two limitations mentioned under the family code: the death of the child and the death of the parent. These provisions do not make any distinction whether or not the petitioner was born before or after the death of her putative father. What matters is that her alleged father had already died. The Honorable Supreme Court in Hilario versus Miranda held that the rationale for the time limit to bring an action for compulsory recognition is to protect the legitimate family. The latter are not in a position to explain or contradict the circumstances surrounding the procreation of the illegitimate progeny. To inquire into these circumstances, after the parent has died, when no one else can fully prove the truth or falsity of the alleged filiation of a claimant, is to penalize unnecessarily the legitimate family that constitutes one of the foundation blocks of the society. Respondents are not estopped from questioning petitioner's filiation. First, there was no judicial admission that petitioner was the illegitimate child of Arturo. Second, before estoppel can even set in, petitioner has to prove the facts from which estoppel is based. However, the petitioner did not even prove her illegitimate status. She did not present her birth certificate showing that indeed she is illegitimate. What appears on record is a certificate of live birth of a person bearing the name of Maria Angela Kwan Ho, born to Susan Kwan and Enrique A. Ho on October 9, 1978. It is physically impossible that Susan Kwan could give birth to two children on the same day from two different fathers. Third, the petitioner did not present any evidence to prove the alleged overt acts of the Aquino clan. Other than her self-serving allegations, no testimonial or documentary evidence was presented to this effect. The court cannot consider evidence which has not been formally offered. In cases involving recognition, paternity or filiation should be established by clear and convincing evidence. Lastly, such alleged overt acts must refer to the acts of the father himself, not his relatives, as held in Mendoza versus Court of Appeals. The constitutionality of Article 992 of the Civil Code was not raised at all in the settlement proceedings. The appellate jurisdiction of the Honorable Supreme Court under the Constitution, in cases involving the constitutionality of any law, pertains to final judgments and orders of lower courts involving this issue. There was never any final judgment or order of the Regional Trial Court or of the Court of Appeals disposing any issue on the constitutionality of Article 992. The question of constitutionality must be raised at the earliest opportunity, so that if not raised by the pleadings, ordinarily it may not be raised at the trial, and if not raised in the trial court, it will not be considered on appeal. Fairness and due process dictate that evidence and issues not presented below cannot be taken up for the first time on appeal. Assuming that the Honorable Supreme Court ought to take cognizance of the belated issue, Article 992 as currently interpreted and in itself is not unconstitutional. It does not violate the equal protection and due process clauses of the Constitution. The term relative was correctly interpreted in Diaz versus Intermediate Appellate Court to comprehend all the kindred of the person spoken of. The reason for the prohibition is not so much on the line, whether collateral or direct, but on the division between the family bound by marriage and that which exists out of wedlock. Equal protection simply requires that all persons or things similarly situated should be treated alike, both as to rights conferred and responsibilities imposed. It allows classifications as long as they are reasonable and not arbitrary. Article 992 is based on substantial distinctions. If the parent of an illegitimate descendant is a legitimate child, that legitimate child has a legitimate family or relatives in the ascending or collateral line who are being protected by the intrusion of an illegitimate descendant into their estate. To grant the interpretation sought by the petitioner would be unfair and anomalous, in that an illegitimate child who is 2 degrees away from the decedent would be able to get a share equivalent to that of a legitimate child who is only 1 degree away from the decedent. Persons who are not similarly situated should not be given equal rights. There is no violation of due process, even while Article 992 lays down a presumption that admits of no evidence to the contrary. The entire law on intestacy itself is premised on the conclusive presumption as to what would have been the wishes of the decedent had he left a will. To allow individualized determination will contravene the state policy on orderly property disposition, as anyone will be allowed to claim priority because he in fact enjoyed greater affection from the decedent. If this situation were allowed, there is danger that unfounded claims of supposed preference can supplant the actual intention of the decedent had he left a will. Article 992 does not make any distinction between relatives of the legitimate parent in the direct line or in the collateral line. The reason for the reciprocal prohibition under the law is not so much on the ties of blood that exist, or the line, or the proximity of relationship between the ascendant and the illegitimate descendant, but because there is a factually, legally, and constitutionally recognized division between the legitimate family and the illegitimate family. To construe the term relatives as only referring to collaterals will wreak havoc on the other provisions of the new Civil Code, where the term relatives is mentioned. If Article 992 is construed to refer only to collaterals, then we can expect cases in the future questioning these other provisions as well. Article 992 is in harmony with all the other provisions relating to the right of representation of legitimate and illegitimate descendants. If this law will be limited only to the collateral relatives or will be struck down altogether, there will be confusion as to the other affected provisions of the new civil code. The classification between illegitimate descendants of legitimate children and illegitimate descendants of illegitimate children is germane to the purpose of the law. Between the legitimate and illegitimate families, there is presumed to be an intervening antagonism and incompatibility. The law does no more than recognize this truth by avoiding further grounds of resentment. No less than the Constitution recognizes the dividing line between the legitimate and illegitimate family by providing as a state policy that marriage is the foundation of the family. Considering that an illegitimate is an outsider insofar as the legitimate family is concerned, and vice versa, the law has provided a mechanism that will prevent one from stepping on the toes of the other, so to speak. Hence, the reciprocal prohibition. This law does not penalize a person based on his illegitimate status. Even the legitimate relatives are prohibited to inherit from the illegitimate. We cannot say in such case that the legitimate relatives are penalized on the basis of their legitimate status. Article 992 is a referee between the legitimate relatives and the illegitimate child. If these groups really want to give to each other mortis causa, they can do so by the simple expedient of executing a will, which is the best proof of the presence and extent of their affection, if any, to each other. Thank you, Your Honors.
Any questions? We will continue with the presentation for the respondents. So we ask, please take your seat. Thank you. We'll ask the Solgen to make his presentation. And then we will ask the amicus curiae. Are you not presenting for Abdulah and Rodolfo?
Only for Rodolfo Aquino, Your Honor.
You're for Rodolfo. Okay. We'll counsel for Abdulah to make her presentation. 10 minutes.
Good afternoon, Your Honors. I'm Attorney Geraldine Vicky Mosingq, respectfully appearing for Respondent Abdulah C. Aquino in GR number 208912. On the issue of filiation, we respectfully submit that procedurally, petitioner is barred from establishing her filiation to Arturo C. Aquino, whether under the Civil Code or the Family Code, and petitioner's claim of filiation is not appropriate in this estate settlement proceeding. Petitioner asserted her claim of filiation to Arturo in her motion to be included in the distribution and partition of the estate filed in Miguel T. Aquino's estate settlement proceeding. There, she expressly admitted having been born to Susan Kwan on October 9, 1978, long after the death of Arturo on January 10, 1978. She, however, did not disclose her real name or her own birth record. This crucial omission enabled her to pursue her claim of filiation to Arturo all the way to this honorable court, pleading for equity in light of what she calls a legal vacuum hounding her predicament. However, petitioner has expressly admitted that the birth record registered in 1982 in the name of Maria Angela Kwan Ho, signed by Susan Kwan and a certain Enrique Ho, is hers, and that she used the same in school and in obtaining her Philippine passport. This birth record contained the sworn acknowledgement of Enrique, claiming her as his own illegitimate child. To date, petitioner's birth record has not been modified or cancelled. Consequently, Enrique's acknowledgement of petitioner stands, and it effectively bars her from establishing her filiation to Arturo. Petitioner's judicial admission demolishes her legal vacuum theory and creates instead a formidable obstacle to her claim of filiation to Arturo in Miguel's estate settlement proceeding, given that as things now stand, her right to inherit is enforceable against Enrique, and not against Arturo or any of his relatives, whether under the provisions of the Civil Code or the Family Code. On the substantive issues on filiation, we humbly submit that petitioner is not a legally recognized illegitimate child of Arturo. Respondents are not stopped from questioning petitioner's filiation, and the Aquino clan's overt acts do not translate to legal recognition of petitioner's status as Arturo's child. Petitioner presented no evidence before the court of quo, rendering her allegations of filiation to Arturo unsubstantiated. Worse, these allegations pertain to her supposed open, public, and continuous recognition by Miguel, who is not her alleged father. This is contrary to the basic rule that recognition must be made by the alleged parent himself. Here, petitioner failed to show, much less allege, a single act of Arturo recognizing her as his child. There being no evidence presented before the trial court, the factual allegations from which the claim of estoppel might arise were never established, and no competent evidence exists to prove the alleged overt acts of the Aquino clan to bolster petitioner's claim of filiation. Abdullah's being the supposed godparent of petitioner does not stop him, given that the baptismal certificate was not even signed by him. Abdullah's submission with motion, filed on November 25, 2013, likewise contained no admission that petitioner is Miguel's heir. Abdullah's comment, dated November 14, 2003, was in response to the petition filed by Rodolfo and not to the petitioner's motion. On the constitutional challenge to Article 992 of the Civil Code, we respectfully submit that procedurally the constitutionality of Article 992 has not been squarely raised in the settlement proceeding. The constitutionality of Article 992 was not raised at the earliest opportunity. It was only in the supplemental motion for reconsideration filed with the Third Division of this Honorable Court that petitioner had, for the very first time, raised the constitutionality of Article 992, claiming that its present interpretation violates the Equal Protection Clause. Thus, there exists no order, decision, by the lower courts on the constitutional issue which this Honorable Court may review, revise, reverse, modify, or affirm on appeal. Also, petitioner directs her constitutional challenge against the decision of the Court of Appeals on its interpretation of the term relatives in Article 992, thereby seeking declaratory relief on that decision. This, however, is not allowed given that court orders and decisions are not proper subject matters of declaratory relief. More importantly, petitioner has no standing to question the constitutionality of Article 992. She does not stand to be injured by the current interpretation of said law, given that her disqualification to succeed Miguel is primarily due to her apparent lack of filiation to Arturo. Indeed, even if Article 992 is declared unconstitutional, she will derive no benefit from it since she still cannot succeed to Miguel's inheritance. On the substantive constitutional issues, we humbly submit that, in itself and as currently interpreted, Article 992 does not violate the equal protection and due process clauses of the Constitution. Article 992 cannot be interpreted to allow illegitimate descendants of legitimate children to inherit ab intestato from their ascendants. Illegitimate descendants of both legitimate and illegitimate children are generally similarly situated, and the classification between the two sets of illegitimate descendants is germane to the purpose of the law. As currently interpreted, Article 992 is applied literally. Thus, the prohibition on reciprocal intestate succession between an illegitimate child and the legitimate children and relatives of his father or mother is absolute and admits of no exception. This is in recognition of the principle that an illegitimate child's right is direct and immediate in relation to the father or mother who acknowledged him, but cannot be indirect by representing them in the succession to their ascendants to whom he is not considered related in any manner. Furthermore, the prohibition recognizes the presumed intervening antagonism and incompatibility between the legitimate and illegitimate families and seeks to further avoid further grounds of resentment. Given that the absolute prohibition in Article 992 is reciprocal in nature, it is not unfair or unreasonable. Neither is it discriminatory, as the absolute prohibition rests on a valid and basic distinction between legitimate and illegitimate children. The law itself recognizes this distinction when it treats these children differently, taking into account the protection accorded by the state to the institution of marriage, the family, and its patrimony. Thus, the rights granted to legitimate children vis-a-vis illegitimate children are not the same, particularly when it comes to succession. An illegitimate child is required to first prove his filiation duly acknowledged by the alleged parent before he can inherit from the latter. He then becomes entitled to his hereditary share, equivalent to 1/2 of the share of a legitimate child. As to the right of representation, this is permitted when his parent is illegitimate and only when there are no concurring legitimate children or relatives of his parent. In interpreting Article 992, the term ascendants fall within the plain and ordinary meaning of the word relatives. To exclude ascendants from the term relatives is a question of policy that must be addressed by Congress as recognized in Diaz versus Intermediate Appellate Court. Generally, all illegitimate children are similarly situated as the Family Code had removed their previous subclassifications. However, taking into account the provisions of Articles 988, 989, and 990, the absolute prohibition on reciprocal intestate succession in Article 992 somehow results in a different subclassification of illegitimates based on the status of their parents that affects their right to inherit by representation. We respectfully submit that the resulting subclassification is again premised on the basic distinction between legitimate and illegitimate children, the presumed intervening antagonism and incompatibility between their families, and the intent of the law to avoid further grounds of resentment between these families. Indeed, to allow illegitimate descendants to inherit from the legitimate children and relatives of their parent will result in the distortion of hereditary shares that the law had carefully allocated to each class of heirs. In the case of petitioner, for instance, if she is allowed to represent Arturo in the inheritance of Miguel, she will be entitled to the same share as the other legitimate children of Miguel. Supposing that Miguel has other children by his second wife, and one of Arturo's full-blood siblings dies without issue, petitioner's share would then become greater than the share of each legitimate half-brother or half-sister. The resulting distortion will only breed resentment, if not full-blown conflict between the legitimate and illegitimate families, all of which can be avoided by maintaining the absolute prohibition in Article 992. We respectfully submit, Your Honor.
Thank you, Counsel. We will ask the Solgen to make his presentation now, 10 minutes also.
Good afternoon, Your Honors. Before I proceed to deliver my opening statement, Your Honors, may I be allowed to furnish you copies of the marriage contract, Your Honor, before I begin my speech?
Yes, please go ahead and distribute that. Will the clerk of court get the copies?
Aside from the marriage contract, Your Honor, we also attached the certification, and the judgment of the compromise agreement.
Solgen, can you furnish also the counsels for respondents?
May it please the Honorable Court, Your Honors, let me get down to brass tacks. The OSG submits that this case before the court is not the proper case to test the constitutionality of Article 992 of the new Civil Code. Why? Because the petitioner Amadea Angela K. Aquino, or Maggie for short, is not a member of the Aquino family. Under Philippine law, she is Maria Angela K. Co, the daughter of Enrique Ho. During the September 3, 2019 oral arguments, Maggie admitted that her birth certificate under the name of Maria Angela K. Ho bore the entry and signature of Enrique Ho as her father. She even averred that she used the said certificate in her school and government transactions. Maggie's judicial admission has two inevitable legal ramifications. One, Maggie's legal father is Enrique Ho, not Arturo Aquino. Her claims that the entries in the birth certificate were made only for convenience is balderdash. A birth certificate, being a public document, is a prima facie evidence of the facts stated therein. If it were true that Maggie's father was Arturo Aquino, she should have impugned the recognition made by Enrique Ho within 4 years following the attainment of her majority under Article 281 of the Civil Code. This action to impugn recognition should have also preceded Maggie's motion in the interstate proceedings of the Aquinos. But Maggie junked both remedies. How then can Maggie claim to be an heiress of the Aquinos when her father is Enrique Ho? Incidentally, Enrique Ho married Susan Kwan, the mother of Maggie, on July 3, 1986. Under Article 178 of the Family Code, legitimation shall take place by a subsequent valid marriage between parents. Number two, to allow Maggie to inherit from Miguel Aquino will unfairly merge two separate and distinct successional lines, the Aquinos and the Hos. As Enrique Ho is the registered father of Maggie, he has the successional rights over the portion that Maggie will receive from Miguel Aquino's estate, if any. In effect, a total stranger will be able to partake in the subject estate to the detriment of the legal heirs. These are enough grounds for this court to dismiss the petition even without verging into the constitutionality of Article 992 of the new Civil Code. In deference to this court, I will address the issues in the advisory. First, Maggie is barred from establishing her filiation to Arturo C. Aquino for failing to file her claim within 4 years from the attaining of age of majority pursuant to Article 285 of the Civil Code. When Maggie was born on October 9, 1978, the governing law on filiation was still the Civil Code. Under Article 285 thereof, if the parent of a minor natural child dies before an action for recognition is filed, the action may be filed before the expiration of 4 years from attainment of majority. Maggie did not file such action. Pertinently, this court in Bernabe versus Alejo ruled that illegitimate children who were still minors at the time the family code took effect and whose putative parent died during their minority are thus given the right to seek recognition for a period of up to 4 years from attaining majority age. This vested right was not impaired or taken away by the passage of the family code. Following the ruling in Bernabe and through simple arithmetic, Maggie could have sought recognition until the year 2000 only, but she did not do so. This brings us to the second procedural issue in the advisory on whether Maggie's claim of filiation through a mere motion to be included in the distribution and partition of the estate of Miguel Aquino is appropriate in an estate settlement proceeding. In Guy versus Court of Appeals, decided on May 12, 1964, the court's jurisdiction in a settlement of estate proceeding extends to matters incidental and collateral to its powers, handling the settlement of an estate, including the determination of heirship. In effect, Maggie's motion could have ripened into a valid claim of filiation if she were an Aquino, but she was not. However, the motion was filed only on July 17, 2003. By that time, her action to claim filiation had already prescribed. I moved on to the substantive issues in the advisory. First, Maggie is not a legally recognized illegitimate child of Arturo Aquino, either under the Civil Code or the Family Code. In this case, Arturo Aquino died before he can even recognize Maggie as his illegitimate child in a public document or in any authentic writing admissible under the Civil Code. Conversely, assuming the Family Code is applicable, Maggie's claim of filiation based on an open and continuous possession of status as an illegitimate child can only be instituted during Arturo's lifetime. But Maggie cannot claim filiation to Arturo Aquino because she is the daughter of Enrique Ho. Corollary to this, the alleged badges of recognition cited by Maggie are irrelevant. Maggie is the daughter of Enrique Ho, not Arturo Aquino. The recognition contemplated by law is that made personally by the putative parent himself, not by any other person, and not by grandparent, brother, sister, or relative. Second, Article 992 of the Civil Code is constitutional, both as to its interpretation and in itself, and it does not violate the equal protection and due process clauses of the Constitution. Maggie's belated challenge against the constitutionality of Article 992 of the Civil Code does not pass the crucible of judicial scrutiny. She did not raise this constitutionality issue at the earliest opportunity in the interstate proceedings before the trial court. Also, she did not adduce any cogent argument to show that the constitutionality of the law is the lis mota of this case. Likewise, the scope of the term relative in Article 992 of the Civil Code had long been settled in Diaz versus Intermediate Appellate Court, wherein this court, sitting en banc and with the aid of several amici curiae, and with only a sole dissent, ruled that the term relative includes grandparents. This court must not also be swayed by Maggie's specious invocation of the constitutional precepts of due process and equal protection of laws. The so-called principle of absolute separation between the legitimate and the illegitimate family under 992 rests on a sound public policy, given the intervening antagonism and hostility that exists between these families. It espouses a valid governmental objective, which is to maintain the distinction and separation between these two bickering sides. Also, Article 992 is not oppressive because it is restricted only in cases of intestate succession. In fact, Maggie has received in the past valuable properties from her alleged grandfather, Miguel Aquino. She must be lucky because she's not even related to the Aquinos. There is a valid classification between illegitimate and legitimate children, and the intent of Article 992 is to maintain this distinction as to their rights of representation in intestate succession. In turn, the classification under 992 is germane to the purpose of the law and applies to all members of the same class. Finally, an illegitimate child has no right to inherit ab intestato from the illegitimate children and relatives of his father or mother. Article 992 of the Civil Code is clear. Illegitimate children are barred from inheriting ab intestato from the legitimate children and relatives of the father and mother. As the law is clear and unequivocal, there is no room for interpretation or construction. Also, it is not within the province of this court to inquire into the wisdom of the law, for indeed, the court is bound by the words of the statute. Neither can the court put words in the mouths of the lawmaker. From the words of a statute, there should be no departure. Thus, unless the law is amended, illegitimate children are barred from inheriting from the legitimate children and relatives of their father or mother. There is a pending bill in the House of Representatives, particularly HB number 01147, which aims to eradicate the distinction between illegitimate and legitimate children as to their status and successional rights. With all due respect, this court should exercise judicial restraint in declaring 992 unconstitutional in due deference to the sole prerogative and constitutional duty of the legislature to enact laws. The legal effect of declaring 992 unconstitutional is the dilution of hereditary rights of the legitimate family as a result of the successional rights granted to illegitimate children. It will also affect the property relations between the husband and wife, especially those whose property regime is governed by an absolute community or property or conjugal partnership of gains. Section 2, Article 15 of the Constitution values and protects the sanctity of marriage. In the case of Tilar versus Tilar, this court, speaking through Justice Peralta, stated that, and I quote, "The state has surrounded marriage with safeguards to maintain its purity, continuity, and permanence. The security and stability of the state are largely dependent upon it," unquote. Indubitably, the Iron Curtain Rule in Article 992 is one of the safeguards provided for by law. To declare Article 992 unconstitutional would allow even adulterous children to inherit from the legitimate family. On this note, let me quote the case of the Santos versus Angeles, wherein this court held that no moral philosophy under our social and cultural milieu can countenance a doctrine that, and I quote, "adulterous children shall not enjoy the status, rights, and obligations of legitimate children," unquote. Some say that Article 992 of the Civil Code violates the 1990 Convention on the Rights of the Child. We respectfully disagree. The present case is governed by the municipal law of the Philippines, pursuant to the nationality principle under Article 15 of the New Civil Code. Also, Article 16 of the New Civil Code states that intestate and testamentary successions shall be regulated by the national law of the person whose succession is under consideration. In any event, this case can even be considered moot. As mentioned by Respondent Abdullah's counsel during the oral arguments last September 3, the trial court had already approved the compromise agreement executed by the Aquino clan involving the subject state. Maggie is not entitled to any share simply because she is not a member of the Aquino clan. In fine, this case is not about the seeming discrimination that an illegitimate child suffers under the present law. Rather, Maggie's tale of two fathers is simply her attempt to have her cake and eat it too. This attempt must fail because he who comes to equity must come with clean hands. The OSG, therefore, Your Honor, prays for the denial of this petition. Thank you.
Thank you, Mr. Solgen. May we ask Dean Cynthia Del Castillo if she's going to make a presentation.
May it please the court, Your Honors. As amicus curiae, I have been asked to render an opinion on the legal issues So at the very outset, Your Honors, I will not deal with the factual issues as to whether or not the petitioner in this case has duly proven her status as an illegitimate child. On the legal issues, however, there are two things that we should consider. Is it the family code or is it the civil code that should govern? We have, of course, provisions in the family code allowing for retroactivity unless, of course, the rights have been vested. The petitioner in this case is seeking to inherit from Miguel. Miguel died during the effectivity of the family code. So his succession opened at the time that the family code was already in effect. So if it is considered that her rights will have to be determined on the basis of the family code provisions, there are two things to consider. You have, of course, Article 172 in relation to Article 175, which means that if you are establishing your illegitimate status on the basis of the second paragraph of Article 172, it will have to be filed during the lifetime of the decedent. But of course, as we all know, she is a posthumous child. At least the allegation states that she was born after the death of her father. So there is no opportunity for her to bring that action if the family code was to be in effect. This is different from the actions to impugn legitimate status, where there are provisions in the family code that deal with posthumous children. Unfortunately, the family code does not deal with proof of illegitimate status of children who were born after the death of their parents. So there is a void in the law which I think should be filled. There are a few things that we have to consider also, Your Honors. Here, we talk about recognition and acknowledgement of natural children. If we all agree that the family code is the one that should be effective in this case, in the family code, we do not talk about acknowledgement and recognition of natural children. The only requirement in the family code is that you should be able to establish your filiation. And in this case, I think Article 172, the second paragraph, allows not only for open and continuous possession of the status of an illegitimate child, but also provisions of the rules of court, which allow for actions and conduct of relatives, not only the person against whom illegitimate status is being claimed. The other thing that I would want to emphasize is that this is interstate succession. In interstate succession, what is the basic principle? The basic principle is that we have to determine what is the intent of the decedent, because this is based on the presumed intent of the decedent. It's not like testate succession where you can determine the exact intent. So there would have to be a determination what is really the presumptive intent of the decedent in this case. With respect to Article 992, I think at the center of this is the provision in Article 992. The jurisprudence that we have at the moment is the case of Diaz. The case of Diaz was decided solely on the basis of the rules of statutory construction. It said that this is a literal provision in 992. There is no room for interpretation because it is clear and unequivocal. The question I pose before you today, Your Honors, is 992 really unequivocal and express? Because in the center of all this, you have Article 982, which specifically talks about the right of representation of grandchildren to represent their parents in the estate of their grandparents. There is no qualification in 982 that distinguishes legitimate and illegitimate descendants. The distinction is, of course, found in Article 992. Diaz says that 982 is the general rule, and that 992 is the exception, and applied 992 to the case in Diaz. Is it really the exception that we have to take into account? I say that insofar as direct descendants are concerned, you apply Article 982, precisely because that provision specifically talks about the rights of direct descendants in the case of the grandchildren representing their parents in the settlement of the estate of their grandparents. In 992, if you consider 992 as the exception, certainly the exception will not cover the general rule, but will cover specific situations. So in that case, while there is a call for unconstitutionality, I think unconstitutionality of a law is, of course, the last priority that should be given. Because we of course, admit the fact that there is a basis for making the law. But what we want to emphasize in this court is, can there be room for purposes of reconciliation of these two provisions? And the reconciliation that was suggested in a few other cases is that Article 982 should be read together with Article 992. It has been raised before that the relatives will have to exclude the grandparents and the direct descendants because that's covered by Article 982, which is very specific and does not apply any form of disqualifications or distinctions between legitimate and illegitimate grandchildren. So on that basis, I would like to take the position that 982 and 992 can be read together. There have been a couple of cases where this court flirted with the idea of making the distinction between legitimate and illegitimate grandchildren. The first of these cases was the case of Manuel versus Ferrer, decided 5 years after Diaz. And in that case, although the facts are slightly different from what we have right now, the court had consistently, you can see it from the four walls of the decision, that they talk only of collateral relatives when they speak of Article 992. The closest that we came to would be the case of Suntay versus Suntay, decided in 2010. The case of Suntay versus Suntay is exactly the same set of facts in this case. If you agree that the grandparent in this case, Miguel, actually had conducted himself to show that in fact he recognized the grandchild in this case. The case of Suntay versus Suntay would have been the opportunity for the court to rule on whether or not 992 applies only to collateral relatives or not. But in the case of Suntay versus Suntay, there was no issue as to whether the grandchild was in fact illegitimate, as in fact one of the grandparents adopted the grandchild. But of course, the estate to be determined there is not the adopting parent, but the other grandparent. So the court had the opportunity then to talk about what is 992. And always whenever we talk about Article 992, you always have the reference to Justice JBL's very esteemed position. And this is that he said that Article 992, if interpreted in its literal sense, would cause first unfairness, because if you remember the case of Diaz, applying this rule meant that it was the niece who would succeed over and above the grandchildren. So if you're talking about how close the relatives who inherited were to the decedent, certainly the niece was far more removed than the grandparent. And if you go about the rules on animosity and the discussion with respect to animosity, which has been raised here and has been raised in all cases dealing with Article 992, the animosity is very clear in the case of collateral relatives because they stand to inherit less. They're not going to be removed from what they have in a form of legitimate, but certainly they would lose the additional inheritance if the illegitimates would inherit. But certainly as far as the grandparents are concerned, grandparents, by human nature, would have no animosity towards their grandchildren, whether legitimate or illegitimate. And the other thing that we want to emphasize, Your Honors, is that filiation is a status that grants legitimacy or illegitimacy to children. There is no such thing as illegitimate parents. There can only be illegitimate children. And for illegitimate children to suffer because of the fault of their parents, including in matters of successional rights, may result in some form of unfairness. So these are the things that have been cited in most of the cases Justice J.B.L. Reyes is very pronounced in his statements about the unfairness, the, in fact, absurdity of the effect of this provision if interpreted in this literal and express sense. Because certainly the premise is that Article 992 is considered as express and unequivocal. The challenge, Your Honors, is to try to see whether or not Article 992 is in fact express and unequivocal. And there is, of course, grounds to say that there is no express and unequivocal provision in 992, considering that you have to relate this provision with the other provisions, Article 982, and then, of course, the other provisions with respect to the right of illegitimate children succeeding to the estate of their grandparents. So with that, Your Honor, we submit that there is opportunity and there is, of course, occasion to revisit the case of Diaz versus Intermediate Appellate Court and to rule, of course, as it started to say so in Suntay versus Suntay, that there is no difference between legitimate and illegitimate descendants of legitimate children. The only issue why the court came short of deciding the provisions of Article 992 is because the only issue raised in the case of Suntay was the power of administration of illegitimate grandchildren. And in Suntay, the court actually said illegitimate grandchildren can be appointed as administrator of the estate of their grandparents because the bar does not apply to them. So with that, Your Honor,
Thank you, Dean Cynthia del Castillo, for that very insightful presentation. So we will now go to the interpellation of the counsels. Justice Leonen, please.
Can I have the counsel for Mr. Abdulah Aquino, please? Good afternoon, counsel.
Good afternoon, Your Honor.
Is your client in the courtroom?
Right now, Your Honor, he has already departed for his travel to Europe, Your Honor.
Oh, and is Mr. Rodolfo Aquino your client here? Can he please rise so we can acknowledge him? Thank you for coming. Thank you. Thank you. You may sit down. Of course, you know that the petitioner had the chance to go back to New York, yet she chose to remain. But of course, you do not know that.
We
correct?
didn't know
Yes.
that, Your Honor.
You know, I've been in the court for 7 years, close to 7 years. And I think to the last person, except me, I know that the court has, many of the members of the court have very strong faiths, that they believe that besides doing law, that we should also do justice. And justice has a few elements. One is that we do the truth and, do what should have happened in the first place. Because after all, none of the courts were present when the family was together. None of the courts was present to actually know what the Rodolfo, the ascendant of alleged
Miguel.
ascendant. Yes, Miguel, the grandparent.
The grandfather.
Yes, and the alleged father of Maggie and the brother of all the other brothers wanted to happen when Miguel died. As a matter of fact, you do have certain documents where the intent of Miguel was clearly said. So in order to arrive at what is just, we have the rules of court and the law in order to guide us. But in truth and in fact, I think that in certain aspects, the law and the rules of court have to be interpreted in such a way to be able to do justice. Because you know, the law and the rules are general. There are unique circumstances in some cases for which we need to adjust in order to be able to arrive at the truth. Well, the long and short of it is I'm just saying that all of us, after doing law, will likewise also be judged at some point. And that I think the family and their counsels will also be judged at one point. And all of us want to be able to do the right thing for the right person at the right time, etc. You know, material things are impermanent. Material things, possession, they're not really that important. It is important simply to acknowledge the relationships of what had been passed. Just telling you. You are familiar with the judgment on a compromise agreement. Is that not correct?
Yes, Your Honor. I have with me the certified true copy.
You were given, we do not have the certified true copy, but that is not important because the Solicitor General, as always, can be relied upon to present dramatic documents, if I may say. But this is not as dramatic as his last submission to us, if I know he knows what I'm talking about. So in the judgment for compromise agreement, you acknowledge that this is the handiwork of Abdulah, your client, Rodolfo, the heirs of Wilfrido, and Enery B. Aquino, as approved by Judge Emmanuel Carpio. Is that not correct?
Yes, Your Honor.
Yes, of course, Judge Carpio, just for the public to know, is related to our acting chief, but that is not a ground for any inhibition or recusement. Okay. Can I ask you to turn to page 2 of the compromise agreement? Okay, in page 2, subparagraph letter G, there is an acknowledgement that in the deathbed of Miguel T. Aquino, he directed that certain properties owned by him be given to his heirs and or devices and legatees. Do you see that sentence?
Yes, Your Honor.
Yes, so it acknowledges here, so all the parties have acknowledged that Miguel Aquino has instructed giving certain properties to his heirs, devices, and legatees. Is this not correct?
Yes, Your Honor.
Yes. And in the enumeration, there is there, in front of LTA, Volcan Street, it says to Maggie Aquino, correct?
Yes, Your Honor.
And would you know who this Maggie Aquino is?
Based on what the client said, Your Honor, it would refer to the petitioner in this case.
The petitioner who is there right now at the back.
Yes, Your Honor.
So there was an intention by Miguel Aquino, as acknowledged by all the heirs, that she would be given the lot in front of LTA. I'm not familiar with LTA. I am not from Davao, although I love that city. Volcan Street to Maggie Aquino, correct?
LTA would refer to the initials of Mrs. Linda Talisik Aquino, Your Honor.
Yes, probably all of you know that. But my point is that there was here, in the intention, the name
Yes.
Maggie Aquino. Is this
Yes,
not
Your
correct?
Honor.
So Maggie Aquino was known to Miguel, correct?
Yes, Your Honor.
She was, not only a simple acquaintance, she was not a helper, she was not just a friend, but somebody to whom Miguel T. Aquino, for one reason or the other, wanted to give a substantial property, which was real property, correct? A lot in front of LTA in Volcan Street.
Yes,
correct?
Your Honor, based on this document.
Based on this, so you
Yes.
acknowledge the existence of this document?
Yes, Your Honor.
Yes, and by the existence of this document, you would say that all of them, and in your position, except Maggie Aquino, are compulsory heirs.
Yes, Your Honor.
Yes, except Maggie Aquino.
Yes, she's not an heir.
Why
Your Honor.
is she in the document? Why is she being given a lot by Miguel?
I really cannot tell, Your Honor, because that was what was dictated
Yes,
by
but
Miguel
we
on
need
his
to
deathbed.
interpret this judgment on a compromise, which was submitted to us by the Solicitor General, which is, of course, no longer a question of fact because it is a judgment based on a compromise, which means the parties have already agreed that there is a person whose name is Maggie Aquino, there is a person whose name is Miguel Aquino, there is an intention at the deathbed of Miguel Aquino. You know, when you are at your deathbed where everything will become final, you would not do anything which you think is false, correct? Would you, if you were Of course, none of us
I
will know.
cannot tell, Your
Yes,
Honor. But yes, I suppose.
With finality and our mortality confronting us, and for those that believe in life hereafter, whether nirvana or heaven or the great void, your life, your mortality will end, and therefore, there would have been a reason for Miguel T. Aquino to actually give to Maggie Aquino, correct?
We suppose so, Your Honor.
He
yes.
was working within lucid intervals at this time, correct?
That I cannot tell, Your Honor.
Your client will know.
At his
Rodolfo
deathbed, Your Honor,
Aquino signed as witness, Miguel Aquino signed, and this entire document was likewise acknowledged by all the heirs as being a real document. There was no question as to its authenticity, correct?
yes, Your Honor, but
So-
I'm not representing Rodolfo, Your Honor, just for the
Yes,
record.
but your client also signed the compromise agreement, correct?
Yes, Your Honor.
Which included these instructions.
Yes, Your Honor.
It's attached as Annex A even to the compromise agreement, correct?
Yes, Your Honor.
And also as Annex A to the judgment on a compromise. Is that not correct?
yes, Your Honor.
Yes. So there must have been a reason, and back of our minds, back of my mind, I cannot speak for my other colleagues, back of my mind, what's bothering me is, why is there an acknowledgement by Miguel Aquino to give to Maggie Aquino, and all the heirs accepting that Maggie Aquino should have it, and were it not for the Court of Appeals decision now being questioned, according to this document, they would have honored the wishes of Miguel Aquino. Is that not correct?
Yes, Your Honor.
And I read to you that portion. Accordingly, the heirs have agreed to honor the decedent's dying instructions and shall implement his instructions in this agreement in a manner that will not contradict the decision. Were it not for the decision of the Court of Appeals now being questioned, they would have given to Maggie Aquino. Is that not correct? According to the stipulations in this judgment on a compromise, quoting directly from the compromise agreement.
That, Your Honor, plus the fact that her birth record had surfaced later on, Your Honor.
It's not here. What I'm just seeing is this judgment on a compromise, because your position is the factual circumstances have already been laid out. They did not present evidence, but I am now in possession, and you are now in possession, and this court is now in possession of a judgment on a compromise acknowledging the act of all the heirs where the name of Maggie Aquino is included.
Yes, Your Honor.
Yes, okay. Can you cover this in your memoranda? What is the significance of this acknowledgement that there is Maggie Aquino, and as far as all of us are concerned, unless you under oath will say that it is not the same person that is sitting in the first row at the back of the Office of the Solicitor General's panel, okay, then we would have no problem that this refers to the petitioner, correct?
I believe it refers to the petitioner, Your
Yes,
Honor.
so you would have to tell us what the significance or non-significance of that thing here. And that all the decedents said they were about to honor the dying wishes of Miguel Aquino, who in some faiths would probably be looking at us right now and actually telling us, why are you going through all of these things? I already gave you instructions, perhaps, because I do not know whether there is a spirit or a life hereafter. But my point is that perhaps there is some reason behind this, that Maggie Aquino is here, and she is not the kind of interloper that some of the presentations have made her out to be, that she is an outsider in the family, belonging to another father, with the mother who is unrelated to the Aquinos, but somehow Miguel Aquino instructed the writing that she has the family name Aquino here, correct? This is an instruction.
Your Honor, this was written by the grandson, Miko.
Yes, but
So
acknowledge.
at the actual saying of the words might not even be Maggie Aquino. It might just be
Yes, but
Miko
all of you
who
acknowledge that there was this
signed it.
document.
Yes, Your Honor. As far as
Where
what
it
is
has
written
Maggie
here, Your
Aquino.
Honor. Yes, Your Honor.
And where you acknowledge that the family name of Maggie was Aquino.
In this writing, Your Honor?
In your compromise agreement, which all the parties signed with the advice of counsel, which the judge acknowledged and therefore rendered a judgment on a compromise. No questions asked.
Yes, Your Honor.
There is the word Maggie Aquino.
Yes, Your Honor.
So here, there is the name Maggie Aquino.
Yes, Your Honor.
Okay, so can you please cover this?
I will, Your Honor.
You are familiar with the principle that this court cannot only look at a particular law that is alleged, but because it is the Supreme Court and a court of law, it has to look at all the laws that are relevant in terms of the interpretation of a specific law that is invoked.
Yes, Your Honor.
In other words, we cannot just be corralled into 992 and the words in 992 just because it is what is contained in the pleadings. We have to know the Constitution. Is that not correct?
Yes, Your Honor.
Yes. And in interpreting a particular law, this court cannot do an injustice. It cannot do something that is unconstitutional. Is that not correct?
Yes, Your Honor.
And this court is not the court in Diaz. It is the same Supreme Court, but its composition is different. Correct?
Yes, Your Honor.
And between 1990 and 2019.
2019.
Okay? Between 1990 and 2019, I'm losing my focus, I'm sorry, there was a significant event with respect to the rights of the child, and this was the ratification of the UN Convention on the Rights of the Child. Is this not correct?
Yes, Your Honor.
What is the effect of a ratification of a treaty? Is that treaty part of the law of the land?
It becomes part of the law of the land, Your Honor.
I know your argument regarding classification, but in your memoranda, kindly cover the effect of Section 2, particularly the word birth. No
Yes,
discrimination with respect to birth. Its effect now on the interpretation on 992, not the unconstitutionality, but the interpretation now of 992, given that, according to our amicus, in Diaz, the amicus concentrated on statutory construction, meaning to say how to read the law within itself rather than actually look at other things which were in the context of this particular law. Okay. Had the brother been alive, the alleged father of Maggie, had he been alive, he would have also been a compulsory heir, correct?
Yes, Your Honor.
And if he were a compulsory heir, had he been alive, he would have gotten a share of the property or the estate of Miguel. Is this not correct?
That is true, Your Honor.
And had he died prior to Maggie, Maggie would have gotten it from him. Is this not correct?
If she were legitimate, Your Honor.
Probably, but he
Under
will
the
know.
present law, Your
He
Honor.
will know whether Maggie is his real offspring.
Yes.
Whether you call her legitimate or not, I would rather not emphasize on that term. To me, it carries a bit of a cultural discrimination, which I do not like, but it is in the law. So I will try to avoid and say that had his father been alive, if Maggie was a real offspring, he would have wanted Maggie because she is the only offspring to have it, had it been true that she was the offspring. Is this not correct?
Yes, Your Honor.
And this is called, if he died earlier, right of representation to a legitim. Is that not correct?
Yes, Your Honor.
And it is a principle that we have to preserve the legitims of all the lines of a particular family. Is this not correct?
Yes, Your Honor.
Is he represented in the in the judgment on a compromise? Is
No,
the
Your
alleged
Honor.
father represented here?
No, Your Honor.
No, because except for Maggie, there was no other offspring that presented himself for representation. Is that not correct?
Yes,
And
Your Honor. There are no other offspring.
If it is true that Maggie is indeed the offspring, if that is true, and of course there are differing opinions, if that is true, then there would be no question as to the amount of share, because the descendant of the son of Miguel, okay, had the descendant been only one, would get the entire representation. Is that not correct? It goes
Assuming-
down before it goes
Yes, Your Honor.
upwards or sideways, correct? That's a principle of
Yes,
succession.
Your Honor, without
Yes.
looking into whether legitimate or illegitimate, Your Honor.
Yes. So it is possible that because we want to preserve the compulsory, the legitimacy of the compulsory heirs, if it is actually proven, if we hurdle that aspect of filiation, then this is just preserving the legitim. Okay. A while ago, I asked, and this is just me, because this court has to act as a collegiate body. Supposing this case is remanded in order to get at the facts, you see, perhaps truth is more important than anything else, truth and justice, without directly contravening the law. Okay? Now, supposing that we will remand it to the trial court, because the trial court did not actually hear the motion, allegedly because there was a paragraph 2 and 3 of the comment that I mentioned, which you will cover in your memoranda. I will not want to cover it now because that will just eat the time of my colleagues. Okay. If this is remanded, particularly your client, would he be open to a DNA testing? Because if Maggie is really the son of Mr. Ho and Susan Kwan, the DNA would be very different. But if she were the son of the daughter of the father she alleges, then even among brothers and sisters, there will be similarity in the DNA. That's the science, correct? Would your client be open to DNA testing? This is just speculative because the court has not agreed on it. We have not discussed it. This is just me.
Your Honor, I haven't discussed that with my client, but we don't see what good will it do, Your Honor, considering that even if filiation is proved, there is still no recognition. And the right to inherit is based on the recognition of the father, Your Honor.
You know where 992 comes from? Siete partidas. You know, in Spain, the siete partidas, 992 no longer exists. No longer exists. And I want you to cover this in your memoranda. What is Spanish law right now? And we have retained a vestige of a colonial law now, which is there, which we need to interpret, but do we interpret it as if we were living in the 1700s or the 1600s? Rather than interpreting it now in 2019, where the world is enlightened by a UN Convention on the Rights of the Child. Of course, you will cover this in your memoranda. Were you counsel in the lower court?
No, Your Honor.
Okay. If we interpret 992, considering the UN Convention on the Rights of the Child, considering the Constitution, are we engaged in judicial legislation?
I believe so, Your Honor.
Really? But
I'm
all
sorry,
of these
Your
are
Honor.
part of the law.
Yes, Your Honor, but
Yes, you
it
mean to say
involves
that
policy.
the only way that we are not engaged in judicial legislation is if we read it according to how you want it read.
Basically, it would be based on the legislative intent at the time of the making of the law, Your Honor.
Of course not. It should be based upon the current law at this time, all the laws. In other words, we cannot be blind to a treaty that was ratified and which became law of the land. Correct?
Even so, Your Honor, as mentioned by the Honorable Solicitor General, there is now a pending law or bill in Congress.
There is a law, and
We
that
believe
law,
that it should be,
there is a law
Congress
now.
should be allowed to pursue that, Your Honor.
The law now is the treaty which we ratified. Section 2, are you familiar with Section 2 of the UN Convention on the Rights of the Child? Do you have it with you?
I don't have it with me, Your Honor, but I
Yes.
remember it was presented last time here.
Yes, and that's part of the law, correct?
Yes,
We
Your
cannot
Honor.
ignore it.
Yes, Your
And
Honor.
we have to read the civil code in relation to the UN Convention. Is that not correct?
Yes, Your Honor.
Okay. Apart from, by the way, this concept of animosity and this thing that you mentioned, that do we have a single solo parent law?
Yes, we do, Your
Yes.
Honor.
And that single parent law acknowledges that single parents with a child is also a family, correct?
Yes, Your Honor.
That they are supposed to be protected alongside those that are lucky enough to still have a father and a mother together. Is that not correct?
Yes, Your Honor.
Yes. And therefore, while marriage is the foundation of a society, it is not true that families where there is no husband or where there is no wife are not second-class families within our jurisdiction. Is that not correct?
Yes, Your Honor.
Yes. And most of the time, when you have a single parent, there is a child who had no choice as to how they had sex, as to the conditions under which they have sex, as to the choice of a sexual partner, and who was born innocent, correct?
It applies to all children, Your
Yes.
Honor, whether legitimate or illegitimate.
Yes. Because I am bothered by your connection of legitimate marriage and family as the only foundation of a family. You, of course, know that some members of this court are not married, and there is a member of this court that is actually divorced.
Yes,
Correct?
Your Honor.
Yes, but the non-traditional setting of that kind of family is not something that should be degraded. Is that not correct?
Yes, Your Honor.
Yes. Okay. Thank you.
Justice Kagiwa.
Just a few questions, Counsel. Just to clarify. Miguel died in 1999,
Yes, Your Honor.
and in his deathbed, he dictated, correct?
Yes, Your Honor.
It wasn't a will,
It's not a
just
will.
dictated.
Yes, Your Honor.
And the dictation was put down in writing by
Miko, Your Honor.
Miguel.
It's Miko, Your Honor, the grandson.
Sorry, by the grandson.
Yes, Your Honor.
And what the instructions were are quoted in this settlement agreement
Yes, Your Honor.
under letter G.
Yes.
My question is, from 1999, no, it says here, lot in front of LTA, Balkan Street to Maggie Aquino.
Yes, Your Honor.
Okay. From 1999 to 2016, who had possession of this property?
I'm not so sure, Your Honor, but none of the heirs were in possession, Your Honor.
You mean to tell me from 1999, at the time of the dictation of this, nothing was partitioned, nothing was divided among the heirs?
There were partial partitions made, Your Honor, but it was finally made in 2016.
So from 1999 to 2016, nobody was in possession of these properties?
I'm not so sure in particular who among the heirs were in possession, Your Honor.
Would the other councils know?
The administrator, Your Honor, according to Counsel for Rodolfo, Your Honor.
No, this is where I'm coming from. You have instructions from the old man saying, I want Maggie Aquino to get lot in front of LTA. Okay.
Yes, Your Honor.
This agreement, according to its recital, says it was to give vent to the wishes of the old man,
Yes, Your Honor.
and that the heirs, including your clients, had executed this to give vent or to give effect to the wishes of the old man.
Yes, Your Honor.
But this is dated 2016.
Yes, Your Honor.
But since he died in 1999, Miguel, I would assume that there was still that intention on the part of everybody to give effect to his wishes, correct? Because 1999 to
Until
2016
the
is-
birth record had surfaced, Your Honor.
No, hold on. Before that happens, in 1999, as soon as he died,
Yes, Your
didn't
Honor.
the children want to effect what the old man wanted?
Yes, Your Honor.
And in accordance with the instructions here, did they give possession of the property in front of LTA, Balkan Street?
At that time, Your Honor, it was the administrator who had possession over the properties of the estate, Your Honor.
Who was the administrator?
Abdulah, Your Honor.
And did he give possession of this property to Maggie?
I am not sure if there was, the title is still with him, Your Honor, and I don't know if there was transfer of possession, Your
No,
Honor.
you're counsel for
Actual
Abdulah,
transfer.
right?
Yes, Your
Isn't
Honor.
this something you should know?
I just came into the picture, Your Honor, late in the proceedings,
Would the
Your Honor. I'm
administrator,
sorry.
I'm sorry, sorry, counsel? You're the lawyer for? Do you know for a fact whether or not this property was given to her? No, I don't have knowledge of that. Who would know? Yes, please.
Your Honor, the property was, physical possession was delivered to Amadea Angela Aquino.
So she got it.
Yes, Your Honor.
And from
Until now.
1999 to the year 2016, she was possessing it.
Until now, yes, Your Honor.
Until now?
Yes, Your Honor.
And now she is still earning income from that property?
There is no income on the property. It's vacant, Your Honor.
So from 1999 to 2016, the property remained vacant?
In 1999, there were lessees, but the lessees have already gone out of the place.
So there's a structure there. There's a building there.
As of now, it's vacant, Your Honor.
No, before.
Before there was, Your Honor.
And she was deriving the income from that one?
Yes, Your Honor.
Okay. I'm trying to understand the history of this thing. So, question to the counsel for Abdulah and for... In 1999, when the wishes were reduced into this note, didn't your clients... Who's the Maggie here? Was it her? Or is it somebody else?
Yes, she's the one
So it's
referred
her,
to here. Yes, Your Honor.
correct?
Yes, Your Honor.
Okay. And during the time from 1999 to the year 2016, you never did anything to question that.
Your Honor, like I said, I wasn't there during the start, and counsel for Rodolfo said that it was actually Abdulah who did the leasing out of the property, and they were in fact the ones opposing it, according to the counsel for Rodolfo.
Who was
Your
opposing
Honor.
what? Sorry?
Rodolfo, Your Honor.
Was opposing...
The act of Abdulah of leasing out the property.
So what are we saying? She never got the rentals? Yes, go ahead, please.
Your Honor, Maggie collected the rentals when there were still lessees in the property because Abdulah delivered the property to her.
Put her in physical possession.
Yes, Your Honor.
What about the title? Is this title property?
Yes, Your Honor.
Has the title been transferred to her?
Not yet, Your Honor.
No. So from 1999 to 2016, to the time that you executed this agreement, everybody recognized her to be the one in lawful possession of this property?
Yes, Your Honor.
I'd like to hear that from Abdulah and the other counsel.
Your Honor, the property was subject of a contract of lease. It was entered into between Abdulah Aquino and the lessees. In fact, Mr. Rodolfo Aquino, my client, filed an opposition to that lease agreement because it is our position that it was not approved by the court. But my client himself, Your Honor, can attest that it was not turned over to Maggie.
So we have a point of difference here. You're saying it was turned over. You're saying it's not been turned over.
According to my client, Rodolfo Aquino, Your Honor.
Can I
and
ask
according to the
Maggie, is she
records.
in possession? Can I ask Maggie if she's in possession?
Your Honor, right now, I don't have the title for it.
No, the possession. Who's there?
Right
Who's
now,
exercising acts of possession over this piece of property?
Right now,
Yes.
I'm not able to lease it out because my uncles are contradicting people who try to lease it.
Beginning when?
I don't recall that. Maybe like a few.
5 years ago, 10 years ago, 15 years ago?
No,
When?
sorry, maybe like around 3 years ago, 4 years ago.
3 years ago?
4 years ago. I'm not sure.
Are you disputing that, counsel? No, I'm asking the counsels for Abdulah and who's the other? Rodolfo. Are you disputing that statement?
What's the statement? What's the statement? What's the statement?
No, but if it was
Until 3 years ago, she was in possession. 3 years ago, that would be 2016, Your Honor.
Yes.
She was not even here, Your Honor. She was in the U.S. How could she be in possession?
You can have constructive possession, counsel.
Well, insofar as lessees are concerned, Your Honor, or lease contracts, there was a contract signed by Abdulah that was objected to by Rodolfo, Your Honor. So there might be some time, Your Honor, during the intervening years where Abdulah took over the property, Your Honor. We just cannot tell at which point in time, Your Honor.
Okay, let me reformulate my question. In 1999, the old man died.
Yes, Your Honor.
In his deathbed, he says, I'm dictating the following. It's put down in writing by Miguel Aquino. I'm sorry, what's his name? Miko? Okay.
Miko, Your Honor.
In 1999. And beginning that time, somebody was possessing that piece of property. It was not Abdulah. Was it her?
There were instances in the past, Your Honor, that the lessee, actually, no, Your Honor, it's not even a lessee. I remember that my client did complain to me that the lot was illegally sold by Amadea or by the petitioner here, without her presenting the original title, which is still in the possession of Abdulah.
No, but in the year 2016, your clients recognized the instructions.
Yes, Your Honor.
And the only thing you did in this compromise agreement is to make that grant of the lot to her conditioned upon what the courts will finally decide in the Court of Appeals case.
Yes, Your Honor.
And that Court of Appeals case was filed when? Prior to, that's what I'm saying, prior to that Court of Appeals coming out with this decision saying 992 prohibits her from inheriting, it seems to me, based on this, that, and the declaration of the compromise agreement that they wanted to give effect to what the old man wanted, then you must have given it to her, correct?
The possession, Your Honor, yes.
Correct?
Yes, Your Honor.
And therefore, she was in possession. And she's the Maggie.
For a while, Your Honor.
Yes,
I
and she's the
believe.
Maggie that is here,
Yes,
that is
Your Honor.
mentioned here.
Yes, Your Honor.
Correct?
Yes, Your Honor.
And it's only because the Court of Appeals came out with a decision that suddenly you say, oops, let's see what the Court of Appeals says, because the Court of Appeals says she's not even entitled to this.
Yes, Your Honor.
Correct?
Yes, Your Honor.
Therefore, my question to you is, when you executed this agreement on the basis of that written statement written down by Miko, wasn't it true that your understanding of Maggie here is as an heir or a devisee or a legatee?
As a devisee, I suppose, Your Honor, because she's supposed to receive a certain real estate.
And why? Would you understand why she was being given a real estate by the old man?
I cannot speak for that, Your Honor.
Is your client here?
No, Your Honor. As I have said, he just departed for his trip to Europe. That was arranged as early as January, Your Honor.
Is that Miko person here?
No, Your Honor, he's in Davao.
Okay. So nobody, not one of you can tell me
Rodolfo
why.
is here, Your Honor. He was there during the instruction being given at the time of, during the giving of the instruction of the old man, Your Honor.
Okay, that's it. I'm fine.
Yes, thank you, counsel. You may take your seat. Justice Hernando.
Thank you, Chief. Good afternoon, Counsel.
Good afternoon, Your Honor.
Let's just try to recall our law and property.
Yes, Your Honor.
Sophomore year in law school, no? You would remember what is meant by res nullius.
Yes, Your Honor.
And what does it mean? Res nullius, a thing that belongs to no one.
No, not owned by anyone, Your Honor.
Yes, a thing that belongs to no one. What about filius nullius? Have you ever heard about it? Filius nullius?
I'm not too sure about the literal interpretation.
I'll tell you what it is, what it means. It means a child who belongs to no one. So can you imagine a child being compared to a thing as belonging to no one? And that is what, in fact, 992 is all about. It has its roots on what I've said during the last session that we had, that it's an obnoxious relic of empire days, colonial law. It's the Spanish that brought this 992 to our shores. In turn, the Spanish got that from the bastardy laws of Great Britain. As I said last time, it's the monarchs of Europe that fostered this concept because of their laws on succession. These monarchs, these kings, had so many wives and therefore had many illegitimate child that in order to remove any friction between and among their many families, these monarchs made it a point that it shall be the first family that shall have all the rights to the monarchy. And so it's an old vestige of empire days, Council. And why should we still adhere to it in this 21st century? Can you tell us why?
Your Honor, in my personal view, I do believe there is a need to look at the law and reevaluate it. It's my position, however, that it is a question of policy that should be addressed by Congress.
All right. Well, what's the Congress?
Yes, Your Honor.
So it's not for this court
Because right now, Your Honor,
to do anything?
based on
We
the...
should just sit back and let this unfairness foster?
We believe, Your Honor,
cultivate?
that there will be other provisions of the Civil Code that will be affected. As mentioned by the Solicitor General, even the absolute community property between spouses will be affected. So it will have a far-reaching effect, Your Honor. So it requires an extensive study and deliberations by Congress, Your Honor.
You say there's a legitimate state policy that is protected by all these provisions in our family code. These are all centered on marriage, no?
Yes, Your Honor.
That status of legitimacy and illegitimacy, at the core of that status is marriage. That's the basis for the classification. Now, with regard to, or in relation to succession, you would say that that's a valid classification, marriage?
Yes, Your Honor.
Why so?
Because in a marriage, Your Honor, the married couple work together to build their own, to accumulate their property and wealth,
All right.
and they would want it
Yes,
to go down
and
to their
if the
children, Your
husband
Honor.
would go astray and sire a child out of wedlock, then he is protected.
The husband, Your Honor?
Yes. The family
Yes,
of the
Your Honor,
husband,
but-
the legal family of the husband is protected by this.
Yes, Your Honor.
Not
Yes.
the non-marital child. Isn't that very unfair to the child? He was brought into the world not out of his voluntariness. He did not.
So do the legitimate children, Your Honor. It's also not their fault as to the circumstances of their birth. Now, if, for instance, there are illegitimate children, I believe smart parents right now provide for them through other means, Your Honor. They can just donate properties, they can just provide for them financially without having to resort to the interstate succession,
Let me
Your
cut
Honor.
you. Whose fault was it that that child was sired out of
It
wedlock?
would be the parents, Your Honor.
The husband, right?
Yes,
In our
Your Honor.
example, it's the husband.
Yes, Your Honor.
And insofar as the husband is concerned, his estate, if he dies, would, well, at least majority of his estate would go to his legitimate children.
Yes, Your Honor.
The non-marital child still gets to have a share, but it's minimal, no? It's just half
Half, Your Honor.
of what a marital child gets.
Yes, Your Honor.
And in the context of how that child came about into this world, isn't it unfair that he just gets half of what the marital child gets?
Again, Your Honor, that would be based on the distinction between these two. I do not say, I cannot,
You know, the protection given by the state to marriage has nothing to do, I would say, with successional rights. How is it related? What standard are you applying, counsel? Is it the strict scrutiny test?
it's the rational basis test, Your Honor, considering that succession is a mode of acquiring ownership.
Precisely.
Yes, Your Honor.
And it has nothing to do with marriage, isn't it?
Yes, Your Honor, but...
Of the successor?
But
Or
as-
I mean of the predecessor?
Yes, Your Honor, but to a certain extent, the distinction somehow has something to do with marriage, Your Honor.
How so?
Because we're talking here of legitimate and illegitimate children. And we do have a state policy, as stated in the Constitution, protecting marriage, Your Honor.
Mhm. Would you mind if I made an example out of you?
Yes, Your Honor.
You wouldn't mind?
I won't mind, Your Honor.
All right. Let's just say that a moment ago, your father tells you, let's just say, that your real mother is someone else. And therefore, you realize that all along, you have been a non-marital child. How would you feel, counsel?
I would feel shocked and betrayed, Your Honor.
Betrayed. How about ashamed?
At the present times, Your Honor, I won't feel that much shame because, as we know, illegitimate children are quite accepted already in our society. There's not much stigma attached to being an illegitimate child or a non-marital child.
So we can therefore say we can dispense with 992 already because the rationality behind the law is no longer there in modern times.
It's still there, Your Honor, considering that there is still that distinction, valid distinction under the law between legitimate and illegitimate children, Your Honor. What I was just saying a while ago was just the feeling that I would get if I discover that I am a non-marital child. What is important to me, Your Honor, would be the treatment that was accorded to me when I was growing up as a child. And if I was loved by my parents, then that would be good enough for me, Your Honor.
Mm-hmm. Okay. Let me just clarify the year when the petitioner gained the age of majority. So she was born in 1978,
Yes, Your Honor.
and therefore she gained the age of majority at which
In
time?
1996, Your Honor.
1996,
Yes.
18.
At age 18, Your Honor.
But insofar as her rights to succession is concerned, it should be the civil code that should still apply, isn't it? The new civil code?
Applying
Insofar as her rights to
succeed,
succession.
yes, Your Honor.
And under the new civil code, the age of majority was then
New Civil Code, it's 21, Your Honor.
21.
Even under the
So-
Family Code, it says 21. Yes, Your Honor. It's only RA 6809, a
Yeah.
year after the Family Code that was passed, that the age of majority was lowered to 18.
Yes.
December 13, 1989, Your Honor. Yes, Your
to be
Honor.
exact. But insofar as her rights to succession, that vested in her when she was born, right?
As far
in
as
1978.
RA 6809, Your Honor, is concerned, lowering the age of majority, it says there that the law will have retroactive effect and except for those contracts such as or wills, donations, insurance policies that are favorable to the child.
Yeah, like in the case of the petitioner. And
In this
therefore,
case,
with
Your Honor, there
respect
is
to
no
her rights
contract
to
to speak of.
succession, No, insofar as the rights to succession is concerned,
Intestate
it
succession.
should be the age of 21 that should govern.
This is
New civil
intestate
code.
succession, Your Honor. There is no written will to speak of that is favorable to her. Therefore, the law lowering the age of majority to 18 will have a retroactive effect insofar as she is concerned.
If we were to grant her another 3 years to claim filiation, that would be favorable to her, isn't it, Counsel?
Yes, Your Honor, but that will no longer be covered by the provision in RA 6809 that limits the non-retroactivity of the lowering of the age of majority to wills, donations, insurance policies, and other instruments that contain favorable conditions or provide favorable conditions to the minor, Your Honor.
Would
was
that
stated
compromise
there.
agreement fall into the category
The
of those
compromise
contracts?
agreement was signed way back, just recently, Your Honor, 2016.
Mhm. The Solgen mentioned of a pending bill in Congress. Now, you're familiar with it?
I am not familiar. I just heard it from him a while ago, Your Honor.
I see. Thank you, Counsel.
Thank you,
May,
Your
may I
Honor.
address my last question to the Honorable Solicitor General, Jose Calida?
Good afternoon, Your
Good
Honor.
afternoon, General Calida. In the United States Supreme Court, the Solicitor General is addressed as General, no? By the justices. So I might as well adopt that address. So General Calida, you mentioned to the court about a pending bill in Congress,
Yes.
leveling the playing field, so to speak, between the rights of legitimate children on the one hand and illegitimate children on the other hand. May we know the status or update or development of this pending bill in Congress?
Your Honor, this bill was introduced by Representative Arlene Brosas of the Gabriela Women's Party and other congressmen from ACT Teachers Party List, Kabataang Party List, Bayan Muna. So this comes from the left wing, Your Honor.
Left wing, okay. Does it do away with 992, General Calida? Is it, or does it seek an amendment or a total abrogation of Article 992, among others? To what extent is there
Would you like me to
equalization
read the
of the rights of the legitimate?
explanatory note, Your Honor?
Yes, please.
Okay. The Philippine government, as a signatory to the UN Convention on the Rights of the Child, is obliged to ensure that the best interest of the child must be the primary consideration in all actions concerning children, including those undertaken by legislative bodies. It is also a primordial duty to take all appropriate measure to ensure that children are protected from all forms of discrimination. The Family Code of 1987 contravenes this duty of the state when it discriminates against children conceived or born out of wedlock. It is prejudice against illegitimate children or those conceived or born out of marriage who cannot and should not be faulted for their parents' marital impediments in the first place. Yet these children suffer the consequences because of this infirmity of the law. Article 177 of the Family Code provides that only children conceived and born outside of wedlock of parents who at the time of the conception of the former were not disqualified by any impediment to marry each other may be legitimated. This may be interpreted to mean that a child who was born outside of wedlock may never be legitimated if at the time of his/her conception, his or her parents were disqualified by any impediment to marry each other. The child may therefore carry an illegitimate status all his or her life. For example, a child born to a couple, one or both of whom is or are below 18 years of age, will never have the opportunity to be legitimated under Articles 177 and 182 of the Family Code. Under the existing legal procedure, to legitimize a child who was born in such situation, parents will adopt every own natural child. Yet the adopted natural child has less successional rights compared to that of his or her full-blooded sibling who was born when their parents are already legally married. If the parents who were earlier disqualified to marry each other but are later on allowed under the law to marry, there is no reason why their children born out of wedlock should not be legitimated by their marriage when the impediment ceases to exist. This situation is unjust and discriminatory against the child. The right of a legitimate and an illegitimate child are not equal in the eyes of the law. Illegitimate children have lesser rights compared to the legitimate children. In terms of inheritance, the illegitimate child is entitled only to 1/2 of the inheritance of a legitimate child. In terms of name bearing, an illegitimate child cannot use the surname of the father without an established filial recognition. This bill seeks to redress such situation that discriminated against the rights of children just because they are born out of their parents' mistakes. Furthermore, this bill advocates for the consideration of all children as legitimate. There is now this bill number 1147. Maybe I'll just have this copied, Your Honor, and give it to you.
Thank you, General Calida.
Thank you, Your Honor.
I have no more questions, Chief. Thank you.
Yes, Justice Reyes.
This is just a follow-up to the questions raised by Justice Kagiwa and earlier by Justice Leonen with respect to the compromise agreement. So can I ask the counsels, the lawyers for Abdulah, and can I ask you some questions regarding anybody? Has the judgment on compromise agreement, has the judgment been executed?
Yes, Your Honor. It has already been executed.
Okay, so all the beneficiaries have already received their share in the inheritance.
Yes, Your Honor.
Now, are you now admitting, as earlier asked, are you or the other counsel now admitting that the Maggie referred to in the judgment based on a compromise agreement, the Maggie Aquino here, who is a recipient of a lot in front of LTA, is the Maggie Aquino here the petitioner?
Yes, Your Honor. She's the same person.
All right, she's the same person. Now, has she received her share? I'm referring to the lot in front of, it could be LTA or MTA, because there's another lot in the judgment, in the compromise agreement. On page 12 and on page 14, there are lots here referring to a lot, MTA, which is also located in Volcan Street.
That is not the same lot, Your Honor.
They're not the
That's
same.
different.
Anyway, now has Maggie Aquino at least received her share, referring to the lot in front of LTA?
She has not received this lot, Your Honor, because under the compromise agreement, this lot is intended for the payment of the obligations of the estate, Your Honor.
All right. So have you computed the value of this lot? Is it more done or less done? You said that this is supposed to be for the payment of the expenses?
Expenses of the estate and the balance will be divided equally between Abdulah Aquino and Rodolfo Aquino.
What do you mean by estate expenses?
There are still estate taxes, Your Honor, which have not
All
been
right.
paid.
Estate taxes.
Separation pay of the employees of the estate,
All right. What else?
and then the operational expenses
What
of the
about
business.
registration expenses?
That's included, Your
Do you
Honor.
do you have an itemized statement of all of these expenses so that these expenses will be divided equally? You know, this is providential. I can say that when Justice Leonen saw this inheritance given to Maggie, this is quite providential because this could be used later on by her to prove that she is one of the beneficiaries, right?
Yes, Your Honor, but it's not mentioned that she's being recognized as an illegitimate
No.
child.
We're not saying that this is a proof of recognition, but this could be used. You see? This
was
could
just
be used in the...
actually-
Okay, just take
Sorry.
it easy.
Sorry, Your Honor, I'm sorry.
You know, the problem is, don't be carried away by your emotions.
I'm sorry, Your Honor. I
All right?
apologize.
Let's be cordial. Let's be respectful. All right? Don't be carried away by your emotions. Now, can you give us, in your memo, a statement of all the expenses? Because you are saying that this lot that is supposed to be given to Maggie has not been given to her because she has to share in the expenses, right?
No, Your Honor.
Oh, right. So what do you mean
What
by?
I mentioned was the lot itself is
Yes.
intended for the payment of the estate expenses.
Whose
and then
is estate expenses?
the estate of Miguel Aquino, Your Honor.
Correct. So your clients, Abdulah, Rodrigo, Rolando, will also share, right? Will also share equally.
The balance of the
The balance of
proceeds-
the lot.
Yes, Your Honor.
Now, why are you referring only to the lot supposed to be given to Maggie? What about the other beneficiaries? Are
Yes,
they
Your
not supposed to share?
They already agreed, Your Honor, in the compromise
All
agreement
right.
that
That's why.
the lot will be used to pay for the expenses, all of the expenses of the estate, Your Honor. And then the balance, if any, will be divided equally
All right.
between Rodolfo Aquino and Abdulah Aquino, Your Honor.
So only the property to be given to Maggie
Yes.
will be charged all of these expenses.
Yes, Your Honor.
Do you have a proof?
This is in the compromise agreement, Your
Correct.
Honor.
Can you cite that to us? All right. How much is the total expenses? All right, so how much is the total expenses? And why are these expenses chargeable only to her share?
Because
Why?
that is their agreement, Your Honor. They don't want to. We admit that there was an oral instruction made by Miguel Aquino, but then the heirs have already changed their mind. They no longer want to honor that written instruction, Honor, because they have already
The
incurred
instruction
expenses.
by the grandfather.
Yes, Your Honor.
So they are disobeying the instruction of Miguel.
They have already changed their mind, Your Honor, because they already
So
incurred
how-
expenses.
How expedient, to give that reason. But at any rate, whatever be the desire of the heirs, the fact is this lot is supposed to be given to Maggie. That's admitted.
That was the instruction,
Now,
Your Honor.
is it true that Maggie had been receiving the rentals? Rentals, is that correct? Up to the present? Louder, please.
In the beginning, Your Honor, when the property was given to her by Abdulah, there were already existing lessees.
All right.
But then the structures were destroyed, and so there are no more lessees. The
Right now.
Yes, sir. The lot is
Meaning-
vacant.
There was a building before,
There were just like structures made of light materials.
and there were how many lessees were there?
Around 3.
Around 3. Now, assuming now, let's go to another point. Assuming counsel, no? Counsel for Abdulah and
Rodolfo, Your Honor.
Assuming now that Maggie will agree to just receive this lot, will you agree? Or will your clients agree? Assuming that we could convince Maggie, because we don't know really what she wants, right? She wants to have a share in the estate. But suppose we can ask Maggie now, if she's satisfied with this lot, are you willing just to put an end to this case? Because if this case goes back to the lower courts, matagal na naman yan, right? And again, this case would again go back to the courts and probably go up to the Supreme Court again. Now, what I'm trying to do now is to find a happy solution. A happy solution, especially for, in this case, the deprived beneficiary. Kasi if you look at the judgment based on a compromise agreement, all the beneficiaries, yung mga magkakapatid, they all have several properties, right? They all have.
There are named persons, yes, Your Honor.
Yeah, they all have. Ito bang mga properties na ito, madadala nila ito when they die? They're all grown up, meaning they're old. I can see one of the heirs here. Baka makasing edad lang kami. No? Malapit na rin kaming mamatay. Di ba? Soldier, di ba? Tumatanda tayo. Ito bang properties na ito madadala natin? Why can't you just give that lot to her and we can convince her to just get this lot? Baka she might be happy with this lot. Right? Can you not give that property to her? Just to put an end to the case. I'm sure the soldier will be very happy. Everybody will be happy. Right? We've been talking about constitutionality of 992. Ang dami natin. Pati yung ating amicus curiae. They're all burdened by all of this. And the bottom line is, the only problem here is properties. Diba? Come to think of it. Baka bukas makalawa. Hindi, mabuti takutin natin eh. Kahapon may lindol nung isang araw. Yung lindol yata, hindi ba sa Davao yung lindol? Saan ba yung lindol? Quezon pala, no? Quezon. Palapit sa atin. There was an earthquake also in Davao. Why can't you just put an end to this case and give that lot to her? And we will try to tell her, convince her to accept it. And that will be, that will put an end to this case. It will be a happy ending. Maggie, come forward, please. Why were you crying earlier? If, Maggie, you listen. If this lot here, I'm sure this lot has a sentimental value to you. Do you know that this was given by your father to you?
Opo.
When he was alive?
Yes, Your Honor.
Buhay pa siya noon.
Yes, Your Honor.
Binigay sa iyo.
Opo.
O nagpasalamat ka ba?
Opo.
Ha? Boy, hindi pa siya patay. Miguel was still alive, but were you happy?
Yes.
Suppose this lot now, is given to you. After all, the compromise agreement says, and they agree and they admit that this lot in front of LTA in Vulcan Street is supposed to be given to you. Pwede bang tanggapin mo na to?
Your Honor, I will be very happy to submit to the court whatever is best they think is
Okay,
gonna
so
be
you
best
see.
for me and gonna be
How
best.
big is the property? And what's the value now? Sino yung attorney? Do you know the value of this property and how big is the lot?
It's about
How do you know? How many square meters? Yes.
It's about 2,000 square meters.
How many?
About 2,000 square meters.
Malaki ito. Commercial ito eh.
And then I heard from the grapevine that the same property in front of it was sold by one of the heirs for 65 million.
60?
5 million.
65 million. Ilang
According
dollars?
to the gossip here.
Ilang dollars yan?
How big was that was sold?
Alright, so
2,000, Your
why
Honor.
can't...
2,000 square meters.
No, the one that was sold at 65 million. How many square meters?
The same. Yes,
Same
Your Honor.
size?
Yes, Your Honor.
Thank you.
So Chief, pwede na yun. 65 million. So why can't you, Maggie says, whatever is the, suggestion of the court, I will abide, right, Maggie? Ibigay na lang sa iyo ito, no? Para matapos na ito. Nobody has been thinking about this, putting an end to this case. Instead of this case, baka mamaya i-remand ito sa, naintindihan mo? Can you understand Tagalog or Cebuano?
Tibuok. Kasabot ko. Bisaya
Kasabot
or-
ka.
Bisaya or Tagalog.
Gusto mo bisayain ko?
Yeah.
Oh, never mind. So Maggie, will you accept this? This lot?
Your Honor, I humbly submit myself to the honorable court. Kung ano po yung
When you say submit, I will abide by what we suggest. I'm suggesting now that you accept this. Wala pang offer. Hindi. Next is sila naman, ho. Yeah, this is just like what we do in the lower courts. Even in the Court of Appeals, we ask the parties to compromise, even at this late stage. Oh. So everybody will be happy. You go back to Davao happy.
Well, Your Honor,
And you go back to the US
I don't
happier.
want this to drag for so long anymore. I already waited so.
Ano yun?
Ayoko na po mag-drag pa po
Ayaw
ng
ng ano?
matagal.
You don't want this case to drag further.
anymore.
That's the reason why I'm trying to help everyone arrive at an amicable settlement, because listening to all of our lawyers and my colleagues here, parang nakakapagod na eh. Di ba? Si Soldier, pagod na rin. Oh. Gusto na umuwi. Umuwi na tayo ngayon. So, mag-agree ka na, and counsels, please advise your clients. Pumayag na. Pumayag na kayo dito.
Actually, Your Honor, we discussed this with our client.
Ano sabi?
My client, for instance, Mr. Rodolfo Aquino. But
Rodolfo.
he is not amenable to a compromise agreement, Your Honor.
Hindi. Compromise agreement. Ibigay mo na lang yung ano. Para... yes, according to Judge Bernabe, that's the wish of the old man. Respect the wish of the old man. Mahirap, if you disobey the words of an old man, I don't know what's going to happen. Hindi ko kayo tinatakot, pero maawa naman kayo. Pag-isipan yung mabuti, and then you let us know. Sana nga ngayon, matapos na yan eh. You try to convince.
We will talk to our client.
It's
Your
just a single property, maybe worth 60 million, and what's 60 million nowadays? Ilang dolyar yan, di ba? Then probably she can have a better house in the United States. So just try to convince. If you cannot convince your client now, sana naman lumambot yung puso nila, and agree to just to give this lot. It's only one lot. And we would like to appeal to your sense of fairness, to your sense of kindness. Di ba? Kindness. Be kind. If the Lord has, been kind to us, di ba, masyado tayong, dapat kailangan may konting pagmamahal. I was given here a biblical verse. It says here, "For my father and my mother have forsaken me, but the Lord will take me in." Di ba? If the parents of Maggie has forsaken her, then perhaps the Lord will take care of her.
She has her parents, Your Honor.
Yeah, yun na nga. So
And
pwede,
Vicky Ho.
I will end my appeal with this, to just give this lot to her, and I'm sure the Aquino family will be rewarded. Will be rewarded. They will be blessed if they agree to give this single lot to her. And you just send your manifestation in court if they so agree, and terminate the proceedings. Right, Soljan?
We will ask our clients, Your
Nag-agree
Honor.
man si Soljan eh. Okay? The lawyer of Abdulah. Oh, what do you say? Will you help the parties? Are you agreeable to that? To giving that lot?
I did discuss this with my client, Your Honor, before he left, and his statement to me was that he was not willing.
Yeah, that was before he
Yes, but we will try and talk to them again, Your Honor, and perhaps open another round of negotiations for this, Your Honor.
Just for this particular lot, ibigay na lang nila kami. Okay?
We will discuss with the client, Your Honor.
Rodolfo is... Rodolfo is here.
Your Honor.
Oh, why can't we ask Rodolfo? Mr. Rodolfo Aquino, I hope that, you will have an open heart, an open mind to put an end to this case. Because this case will not end here if we go, if this case is remanded to the lower courts, magtatagal na naman ho tayo. Pwede ho bang pag-isipan nyo pa ho ng konting reflection, and a little kindness on your part to this poor soul. We don't know Maggie, we don't know you, but this is just an act, an act of kindness to her. After all, you have all the properties, and I hope that you will be kind enough. Build an ark, an act of random kindness each day.
Thank you for your kind remark, Your Honor, but I'm not here in the position to say anything about it. I will let my lawyer do the talking with my brother's lawyer.
So, you're not in a position to say
I'm not
yes
in a
right
position,
now.
Your Honor, yes.
So, bahala ho no yung lawyer nyo.
Our lawyer and my brother.
Okay.
Because he is the administrator, he's the eldest, so he will be the one to say yes or no.
The eldest is Rodolfo.
Abdulah, Your
No,
Honor.
no.
Abdulah, you're Rodolfo.
Yes, sir.
Abdulah.
Yes, Your Honor.
uh,
In fact, she has already sold the properties, Your Honor.
who?
Maggie.
Maggie has already sold the property?
She was the lawyer.
Okay.
Your Honor, we
Nap-
did mention a while ago that my client had reported to me the alleged sale made by Maggie of that property. And despite the fact that she was not in possession of the titles, so she did benefit out of it, Your Honor. And in fact, from what she had admitted a while ago, she already benefited from the rentals that was
Long time
given
ago.
to her, Your Honor.
Long time ago.
Yes, Your Honor.
And you said that the title is not yet in her name. So how could she dispose of the property without the title?
That is why, Your Honor, the title is still in the possession of Abdulah, Your Honor.
Precisely. So how can she how can she have disposed of the property? Paano niya may pagbibili ho yun, Mr. Rodolfo, if the property is still titled in the name of Abdulah? So I think that's not legally possible.
Your Honor, the titles to the property remained with Abdulah precisely because of the compromise agreement
All right.
that it would be intended for the expenses, Your Honor.
All right. But be that as it may now, the property is supposed to be given to her. Kaya napagbili niya na o hindi, bigyan na natin sa kanya. Because the wish of Miguel is for the property to be given to Maggie. That is the wish. Sundin na ho ninyo yung wish ni Grandfather Miguel. Kaya napagbili na yan o hindi? Napagbili na ba yan, Maggie? Has it been sold? You're now stating that under oath? You please rise. Has it been sold? Has it been sold?
No, Your Honor.
This is given under oath.
Yes, Your Honor.
All right, so that's it. She may have benefited from the rentals, but it has not been sold. So I hope, counsels, please try to mediate as officers of the court. Di ba? As officers of the court. It is your duty to help your clients. Hindi lang yung clients nyo, help everyone because we are all public servants. Right? So I hope that we will have a happy ending here. I have no more further questions, Chief.
We note that, Your Honor.
Okay, thank you.
Sayang.
Yes, Justice Xavier.
Chief,
Justice Xavier, please.
May I ask the court's friend, the esteemed Dean Cynthia del Castillo, to please respond to some questions?
Yes, Your Honor.
Thank you, Dean. Good afternoon.
Good afternoon, Your Honor.
Dean, 172 speaks of one way of proving filiation through the open and continuous possession of the status of an illegitimate child. So, as an expert, a noted civilist, can you please enlighten us on these circumstances, specific circumstances, that may constitute proof of the open and continuous possession of the status of an illegitimate child?
Just for purposes of example, Your Honor, there have been facts alleged in this case that will show open and continuous possession of the status of an illegitimate child. Those facts, of course, will have to be proven. One is that she was allowed to live in the ancestral house. Second is that she has been given support by the grandparents. Third is that she has been given this property based on the instructions of the decedent. So those are considered as open and continuous possession of the status of an illegitimate child. I think the Honorable Solicitor General mentioned that this has to come from the decedent himself, but the best way to prove that is in fact, and it is of course admitted by the other parties, that he actually gave her certain properties. There were other facts alleged in this case, Your Honor, that talks about some seats in their auditorium being named after her and that tickets sold were given to her. These are facts which placed together would show that she has been in open and continuous possession of the status of an illegitimate
And I
child.
understand that these facts were not refuted by the respondents.
That's my understanding,
Yes.
Your Honor.
So they need not be proven because the silence of these respondents is deemed an admission.
I agree with you, Your Honor.
All right. And then, considering that based on the undisputed facts of the case regarding the multiple circumstances or acts that would show that, in fact, long ago, even since birth. She has continuously possessed the status of an illegitimate child. Is there still a need for her to go to court and prove anew her filiation?
I agree with you, Your Honor, that she has, based on the facts that were stated in this case, which remain uncontroverted, she has been in possession of the status of an illegitimate child continuously. As to whether she should file an action for that, I stick to the basic principle under the Family Code, Your Honor, that we do not have a system of acknowledgement and recognition anymore. The principle behind the Family Code is for as long as an illegitimate child can establish her identity as an illegitimate child, that is already considered as proof of her illegitimate status.
Yes, and filiation need not be resorted to judicially.
Well, that will have to be...
It doesn't have to be, the party need not go to court to establish it.
I agree, Your Honor, except when it is contested, in which case the courts will have to come in and
All right.
decide.
In this case, considering the undisputed facts regarding the treatment of the respondents and even the father of the father, the putative father, can the court already make a conclusion whether she has in fact been in possession of continuously of the status of an illegitimate child?
Based on the facts, Your Honor, I would say so, yes.
Yes. Would you know of any compelling interest or objective that justifies the differential treatment between legitimates and illegitimates?
None, Your Honor, and I think the recent trend has always been to recognize them as equals on the basis of the fact that they were born into this world not because of any act of their own, but of the act of their parents.
Yes.
So in matters of succession, there should really be no distinction between the two of them.
And even if we transport Diaz into the provision on the prohibition against succession, the Diaz actually qualified, and it's now part of the law of the land, that that provision against succession by the illegitimate children has a condition. The general rule is yes or no to succession by the illegitimate children, but since the factor of animosity is already deemed integrated, and the very reason for this prohibition, does it follow that without animosity it will not apply?
The only reason for the statement of animosity between legitimates and illegitimates is to state the rationale why there is such a distinction.
Yes, so the rationale is the reason why the law came about. It is the spirit
Yes, Your
that
Honor.
breathes life into the law.
Yes, Your Honor.
So, if that spirit is killed, then the letter of the law also dies.
I agree with you, Your Honor, and in fact, if you talk about direct descendants, as a grandmother of 3, I will tell you that I make no distinction whether my grandchildren are legitimate or illegitimate.
Yes.
They're my own flesh and blood, and therefore they should receive the same.
Very well, Dean. Just a last question, Dean. On succession, right? Angela wishes to succeed as by representation, her father,
Yes,
deceased
Your
father. Is she really succeeding to the estate of the grandfather or to the property rights of her father in representation of the latter?
By the principle of representation, Your Honor, under the present laws on succession, she is succeeding from the grandfather in substitution of her father.
Yes. So it is the right of the father that she is exercising. Without the right derived from her father, she would not succeed by representation.
Yes, Your Honor. The situation is that if her father had not predeceased, her father would have received his rightful share, and once he dies, he would transmit them to the petitioner. So the unfortunate event that took place is, of course, the predecease of the father. But by right of representation, she represents her father in the estate of her grandfather.
And the father has not left any other heir.
No, Your Honor.
He has no other child.
From my reading of the records of the case, Your Honor, there's none.
Okay, right? Just one last question. If can we hold the family, the relatives of Angela in Stopel?
It's a factual issue,
Or
Your Honor.
by denying too late in the day the filiation of Angela. Until now, I have yet to hear from them that Angela is not their own flesh and blood.
Yes, Your Honor. My understanding from the records of the case is that there have been no objections until the time that the Court of Appeals rendered its decision. And that's when they change their minds. I think I've heard it over the last couple of hours, even from the counsels of the respondents, that they changed their mind. I think those were the words used. They changed their minds when the Court of Appeals decision came about.
Before the property interests of the parties came in, would you say that the relationship of the parties has been pleasant? There's no animosity between them, and that it only came in because they had to protect their respective property interests?
At least from the grandfather, Your Honor, from whom she expects to succeed, there is absolutely no animosity. With respect to the other collateral relatives, such as the respondents in this case, it may be that there is some animosity because of the material interest.
Where do we reckon the factor of animosity?
I think the whole basis was that if we read the comments, including, of course, the esteemed Justice J.B.L. Reyes, it is because the illegitimate child brings disgrace to the family. And because the illegitimates also hate the legitimates. That was the whole rationale of making the distinction in Article 992. Even in the 1950s, you have already a lot of statements, including those who made the new civil code, that was no longer existing, even at that time. So fast forward 40 years hence, with more reason, I don't think there is any more animosity that's to be expected between legitimates and illegitimates. I think we have come to the maturity that the illegitimates are not illegitimates by their own fault, so we do not rancor any more animosity with respect to illegitimates.
Yes. You have enlightened us on the fact that actually this case we can resolve without having to delve on the issue of constitutionality, and we can actually resolve it in the best interest of the child.
Yes, Your Honor. And I think there are enough provisions in the family code and the civil code that will allow this honorable court to do thus. And I think you have the provision of Article 982, which very clearly and specifically says that grandchildren can inherit by right of representation from the estate of their grandparents without making a distinction between legitimate and illegitimate grandchildren.
982 and 992. All right. So we have to reconcile them. 992, right, is the general rule, and the exception is 998. Is that a reasonable interpretation?
The decision in the case of Diaz, Your Honor, says that 982 is the general rule with
Yes.
respect to direct
982.
descendants.
And
that
the exception.
And that 992 is the exception which they applied in the Diaz case.
All right.
But my own position, Your Honor, is I do not disagree with Diaz. I do agree that Article 982 is the general rule that applies to direct descendants, and that 992, being an exception, should not apply to direct descendants. So they should apply, in essence, to the other relatives other than the direct descendants.
Do you think 982 is still a live law?
Yes, Your Honor, there is no...
Yes.
Yeah.
And we don't have to declare it unconstitutional to come up with a fair, just decision on this case.
No, Your Honor, because my own position is that 982 is really the provision that should apply in the case of direct descendants.
Yes. Very well. Thank you very much.
Thank you, Your Honor.
Our friend. Thank you.
Okay, Justice Bernabe.
Ito, my classmate, can you please go again to the podium? Okay. Dean,
Yes, Your Honor.
you said that for as long as you have proven your open and continuous status as an illegitimate child, you are deemed to have proven your natural filiation. Is the proof to be given during the lifetime of the alleged parent or even after his death?
If, based on Article 172, the second paragraph, Your Honor, it has to be done during the lifetime of the putative parent. Unfortunately, as I did mention, that is impossible in this case because the parent died ahead of the birth of the child. So there is something that has to be filled. It's not like the impugning of the legitimate status of a child where there are provisions for posthumous children. Unfortunately, in this case, for purposes of claiming or proving your illegitimate status, Article 172 does not provide for posthumous children.
And you think the court can fill the gap in this law?
Because otherwise, Your Honor, they will not have any action, they will not have any recourse.
But the recourse is to present the primary evidence, is that correct?
Yes, Your Honor. And again, for purposes of the primary evidence, this is birth certificate signed by the father, which is again impossible in this case because the birth was, the child was born before the death of, after the death of the father. And then, of course, you have the recognition in a private handwritten instrument, which again is impossible because he died ahead of the birth of the child.
All right. Thank you, Dean.
Thank you.
There are no other questions.
Chief, just one last question on my part. Thank you. May I just ask the petitioner to answer my question, Madam Petitioner?
Yes, Your Honor.
You know, Maggie, decades ago, another Maggie blazed the trail for rape victims. No? I'm referring to Maggie de la Riva. And for illegitimate children like you might be just that Maggie who will trail the blaze for children such as you. Now, will a compromise agreement really give you closure?
Your Honor, I will submit to...
No. You look into the deep recesses of your heart and mind. Will a compromise agreement that will give you property really give you closure?
Your Honor, no, because
No. Because all along in your heart, in your mind, you've always longed for family, right?
yes, Your Honor.
And which is why I would say that based on what I've seen of you earlier when you almost cried uncontrollably, you will see this case to its completion, isn't it?
Yes, Your Honor.
For your affiliation to be finally established. It may not be in the eyes of God or of your perceived family, but in your heart, you are a child of your father and your mother, right?
Yes, Your Honor.
That's all, Chief. Thank you, Maggie.
There are no other questions, so we conclude our oral arguments. We require the counsels of the parties to submit their memorandum within 20 days. That means on or before October 7. And after that, the case is deemed submitted for resolution. Any yes, Mr. Soljan?
Your Honor, we just want to be clarified. The Office of the Solicitor General is not a party in this case, so we are exempted from filing the memorandum, Your Honor.
Well, you can file if you want. We prefer that you give us your thoughts so that we can be guided accordingly.
Okay, thank you, Your Honor.
Well, unless a compromise agreement is reached. Also, the amici curiae, if they wish to submit their memorandum, we will appreciate it also. We appreciate their presence here. And we ask the counsels and the parties to stay behind after this oral argument for further instructions from the Clerk of Court. So we conclude our oral arguments and the session is adjourned.
All rise. Please remain standing while the Acting Chief Justice and the Associate Justices leave the session hall.